I am happy to call to order public meeting number 215 of the Mass Gaming Commission, April 27th at our offices at 10 o'clock in the morning. First item up, as always, is the minutes. Commissioner Zuniga, the March 30 minutes, there was a motion made and seconded, and then we tabled it after we made a few reviews.
On that note, I would move that the March 30th meeting minutes be approved as presented today.
Second? Second. Discussion again? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously.
And just for the record, I abstained because I was not present.
Right, Commissioner McDonald abstained. And the 13th.
Similarly, Mr. Chair, I would move that the minutes for April 13, 2017 be approved as presented, subject to any typographical or non-material corrections.
Second?
Second.
Any discussion?
Just a quick spelling error on 10:18 a.m. They misspelled our executive director's last name.
No, come on. 10 a.m.?
10:18.
Oh, that's not the first or last time.
At least you were problems.
Okay, any other discussion? All in favor?
Aye.
Opposed? And again, Commissioner McDonald abstains. Otherwise passed unanimously. We are on the item 3, administrative update.
Yep.
Second.
Good morning, Commissioners. I have a couple items.
Good morning.
One of which, item C, I may ask for a little bit of a delay on, only because we have some folks coming from Springfield who I promised I would not start this without them. I had been alerted there about 10 or 15 minutes after. So, having said that, on a general update, the only thing I would say is I understand we are tentatively planning for our next meeting to be on May 10th, which is a Wednesday,
Right.
as opposed to Thursday. So for people who are watching, that will obviously be posted in compliance with the open meeting law, but we believe it'll be a day earlier.
Right. That's a definite. Yeah.
That's a definite, and I don't think it's definite, it's a definite.
Right.
Thank you. The second item is something that the chairman, I had noticed the chairman brought up previously. I think it's the beginning of the discussion, which is if you look at our core values and mission statement, which are both on our website and then posted in various parts of our office, they appear to be focused and were thought about when the commission was in its licensing stage. When I think I refer to licensing, I talk about the choosing of our licensees, the casinos, as opposed to licensing of employees. Obviously the commission has passed that. So now do we want to think about updating our core values and mission statement as we head towards what I might describe as our steady state operation once the facilities are actually open. To help me with this, I leaned upon our local ethicist, Mr. Grossman, and he made some suggested changes after he and I talked about the core values. It highlighted some areas of the mission statement that we might want to think about. So as I said, this is the beginning of a discussion, certainly nothing to be reached today. Mr. Chairman, I know you would raise this. I don't know if you have any thoughts on this.
I do, but I'll wait until the other commissioners have a chance to speak if you want. Anybody?
Well, I do think it makes sense to highlight the regulation as opposed to the licensing, and certainly adding conflict of interest is one of the other things we deal with on a regular basis. So I liked the changes I saw. And it's more apropos to what we're doing now.
I just think it's always a good thing to kind of come back and revisit, our values and mission statement periodically, like any other organization or business does. But I went through it, had some small tweaks or comments that I guess I can share with Todd if he's collecting.
Well, I for one, think that the licensing that we do, and will continue to do on individuals and vendors and non-gaming vendors, has a place in the core values. So maybe we can find a way to, wordsmith or reflect that more. More clearly, but although I know and realize that when we did these core values, we were clearly thinking about the big licenses, I believe it still applies to all the licenses and registrations that we do of the casino employees and vendors. So I think that's an important part of our mission and core values, and I would say we need to reflect that somehow.
I would agree. I just thought of it as part of the regulatory process.
Fair enough.
So, but I do agree it is an important part of what we do.
Anybody else?
I mean, I found the suggested changes to be fine, and I think that the statement as a whole is excellent, was excellent, continues to be excellent. And licensing clearly remains a very significant part of our function, but as Commissioner Cameron said, she views licensing as part of regulation, which was my reaction as well, but I don't feel strongly about it.
Yeah, the key thing is, as 5 years are under our belt, do we think of a different perspective on core values? And the editing is entirely appropriate and updating, and I have some ideas on that, but at a high level, is this still what we really mean to pull out? And from my standpoint, I think it is. I think we found the sweet spot for the things that we care about as an institution. So it seems like we're in consensus on that, which is great. I also consider licenses at this stage part of regulation, but I wouldn't care if it said licensing and regulation. It wouldn't matter. I like adding the conflict of interest law. I didn't understand why the edit to the burden of compliance to say, this is really down to the wordsmithing, but it used to read, with a thoughtful balance between the need for rigorous regulation and enforcement and the burden of compliance. And you've added, and the burden involved and effort required to achieve compliance. I don't see what that adds personally, but.
Just throwing a thought out there. Burden seems, there's nothing wrong with the word burden, but it seemed as though there's more to compliance, and compliance is not necessarily a burden. It's part of being a licensee. That's how it works. And that's it. So these were just ideas.
Yeah, no, that's fine.
Certainly not cast in stone.
Well, that was the only, moderately substantive one that again, I don't feel strongly one way or the other. I don't think it adds much, but whatever. However, in the next one, we value a diverse workforce and supplier base and an inclusive culture internally, and among the gaming industry. I think within the gaming industry might make more sense.
Yep.
And on the mission statement, I think the two things, did you highlight, are those changes, the yellow?
No,
Is it
those are
different
there.
verbs?
I just I flagged them in that they still are applicable and
Right.
relevant,
Just-
but might be something worth considering whether we consider ourselves still in the implementation phase, or whether the process is still being created, and whether those will withstand the test of time, or we take a look at them now.
Right. Well, I think we're always implementing. I think but I do think that in the sentence above, or the line above, the mission of the Massachusetts Gaming Commission is to create and maintain a fair, transparent. We're past creating. Now our job is to maintain. And I think in the paragraph below, in this third to last line, it says, maximum extent possible, the potential negative and unintended consequences, rather than saying new legislation, which made sense then, might say the gaming law, which references the gaming law up above. Unintended consequences of the gaming law and allow.
Just one more thing, Mr. Chair. In rereading, you know, I probably haven't reread this, although it's up and you see pieces of it, but in rereading this with an idea of, does it need to be improved, it just made me think of, on a daily basis, how much of this is going on in this office, where people really care. They care about making the process stronger, the relationships with stakeholders, all the stakeholders. They listen really well, and I'm just very proud of the work that staff does every single day, and you know, really adhering to these principles. I just think that's not always the case in a workplace where people strive to improve the process, to understand each other better. So I just it made me think of what we do every day when I reread this, and tribute to the staff who really works hard at it.
I agree. Go ahead.
Yeah, I just have one other point. I was just kind of rereading back up to the core values section. I know that most of this was drafted and written when there was a lot of excitement and interest in what we're going to do with respect to expanded gaming. And if I'm not mistaken, probably when we were adopting this, the racing side of the house was still over at the Division of Licensure. But I'm wondering if somewhere in our core values, maybe under that second bullet, talk about regulation of expanded gaming and racing in Massachusetts, just to kind of
Really good point.
offer some due deference to the other side of our house.
Although, Commissioner, we did take racing pretty early on.
We
But-
did,
But
we
it
did.
is a good point to note them specifically, because it's a big part of our operation, and one that we have spent a lot of time and effort to make sure we're regulating properly.
Yeah, I think it's a really good point. I think both in the second paragraph, expanded gaming and racing, and in the next to last paragraph, the Massachusetts gaming and racing industries. That's good.
Yeah, I think they hold up pretty well, 5 years after. I read them with the thought of, what could be missing? What have we been doing that maybe we didn't reflect? And I think it's very balanced. I think they hit the high notes. So
Yeah. And I agree with your comments. The one that, is particularly one of them, they're all important, but the last one, a deep commitment to customer service that assures a respectful and professional experience for all with whom we come in contact, no matter their point of entry or point of view. And whether it's talking about our enforcement people or our receptionist and the people who answer or on the phone, the way we handle MGC comments, I take pride in that. I think we do. And it's a credit to our leadership and to our team. So I feel good about that.
So, Mr. Chair, my suggestion is we'll take your comments today, we'll incorporate them, bring them back. I'll turn left and say whether we need to actually have a formal vote on this. We will determine that. It sounds like we have consensus, but we'll put it together for you. You could take one more look at it. You and Commissioner Zuniga do raise an interesting issue that we may want to discuss at a further point about, we use this term license and licensee very broadly, and I think in our statute, in different areas, it means different things. And at some point, we may want to figure out how to clarify that. I talk about licensee with maybe it's a big L. I talk about our casinos. Licensee small L may be some other component, and that actually does have implications on regulations and stuff like that. So again, just probably a subject for another time.
Right. Okay, good. Anything else on this?
No, thank you.
Thank you, and it's for you and Trupti and Derek, let's make sure that these are integrated into people's orientation packages and wall postings and awareness.
Once we're final, we'll update everything.
Okay.
Thank you. So the third issue, actually, it turns out, we had our stakeholders actually show up so we can go forward with this. And I'd like to make some comments to hopefully help frame the commissioner's thoughts and discussion on this. Commissioners, General Counsel Blue, Director Wells, and I are here today to discuss gaming service employee registration. Specifically, we have focused on the issue of disqualifications of gaming service employees due to certain criminal convictions. By way of background, there's a memo from us in your packet, and I'd like to make a few comments, as I said, to help the commission on this issue. First, we recognize that this issue, which relates for many stakeholders to a larger criminal offender record information debate, is a very important societal issue right now. We also understand that when the expanded Gaming Act was debated and passed by the legislature in 2010 and 11, no one knew where the casinos would be located, who the licensees would be, or the type of commission that would enforce the law. Unquestionably, at that time, the legalization of gaming was a very controversial decision. When we considered the registration requirements, we are cognizant of these issues, along with the declarations by the legislature about the intent of the gaming law in Section 1 of Chapter 23K, as we outlined in our memo. First and foremost, we had to be guided by the law. It is our conclusion that all employees of our casino licensees must be licensed or registered. And that registering gaming service employees subjects them to the mandatory criminal disqualifications of 16B. In reaching that conclusion, we looked to the law to see if there was a rationale for exempting all or some subset of gaming service employees, like we did on the vendor side with the de minimis exemption for vendors from whom our licensees purchase less than $10,000 worth of goods or services. Under the current state of the law, we could find none. Admittedly, 23K, the enabling legislation, is a complex statute around registering and licensing. A word about administrative law. You may remember when you hired me that I spent time at the Attorney General's office, and one of my duties was to oversee the Government Bureau, which included the Administrative Law Division, the group of lawyers who defended the Commonwealth's regulatory agencies in their decisions. As a result, I came to appreciate a few very fundamental tenets of administrative law. One, enabling legislation can be imperfect, especially when it comes to a new subject matter, and the regulatory body enforcing the enabling legislation is often asked to interpret the intent of the legislature. Two, conflicts in enabling legislation are to be interpreted as harmoniously as possible with other sections of the law and the overall intent of the legislation. And three, and I'll look at Commissioner McDonald on this one, courts generally do not like to second-guess regulatory bodies, especially thoughtful ones who recognize and contemplate challenging issues. Just a couple more thoughts before I have some suggestions on process. First, by reaching our legal conclusion on the registering of gaming service employees and the effect of criminal disqualifiers, we do not take a position on the policies debated by the legislature in 2011. Second, while I think we've come a long way in our licensing process since the opening of Plainridge Park Casino and are working very hard to be prepared to register and license thousands of employees in two basic 90-day periods, sometimes in the next couple of years, we have yet to open a Category 1 casino. So our internal data pool is comparably small. Third, this time next year, we'll be on the cusp of MGM's hiring crunch, and staff here is working every day to make sure MGM employees will be registered and licensed on time. You know this, but we're also working on a licensing management system to automate parts of our licensing and registration process, but there will still be human interaction and assessments that need to be made. We further need to work with the appropriate stakeholders to educate potential job applicants on what the actual criminal disqualifier criteria are, what it means to be convicted, the difference between a felony and a misdemeanor, and how someone could attain their own criminal history. Currently, there may be some confusion that has led to the perception that someone must have a clean quarry or they cannot even apply to work at one of our licensees. We absolutely do not want people self-selecting out of applying for a job due to misinformation. In terms of process, I have a couple suggestions. First, we as staff are here to answer any questions you may have. Second, there are many people, some of whom are here today, who have an interest in this and should be given an opportunity to be heard. Third, this is a potentially very broad subject with both legal and policy concerns. It may be helpful for the commission to put out a request for public comment to frame that request. For example, one request might be what specific changes could be made to Chapter 23K to address the issue of appropriate level of review for registering. Another question could be, what can we do to educate potential applicants on the registration requirements as it relates to criminal convictions so they do not self-select out? Finally, folks from MGM Springfield have been especially interested in this issue. And while we as staff have a meeting with them and sharing our analysis informally, this is the first time they will have seen our formal conclusions. I know they will want time to review and I'm sure respond. With all this in mind, I would suggest that after today's discussion, seeking public comment and staff's ability to meet with MGM Springfield staff would take about 30 days. Tentatively, the commission has a meeting scheduled in Springfield on May 25th, which I'm suggesting would be an appropriate date to readdress this issue after today's discussion. Thank you.
Thank you. I think the process you've outlined makes perfectly good sense, pretty much in its totality. And I just, as by way of introduction, I want to comment too that this has been an issue that we've sort of nibbled at around the edges for a long time. It's very complicated in that there are two levels of issue. The first issue is what, if any, what does the statute say? And do we have any discretion in interpreting what the statute says, which is enough of a conundrum. And the second is if we do have room to discretion to interpret the statute, what do we think the right policy should be? That's a conundrum as well. And we have differences of opinion on each of those. So there's kind of a matrix conversation going on here, and I appreciate the fact that everybody has pitched in to try to wrestle this to the ground. But I think what we're starting today is to just say, okay, let's put it on the table. Let's get our differences of opinions if we have them out there, and then we'll go through the very careful and methodical review of our regs as they implement this section of the statutes over the next month or so. Anybody else want to have sort of introductory comments?
Well, let me just, I think again, the process that you outline is really thoughtful. I would like to frame one of the questions at least in the difference between an automatic disqualification, and then there's also the notion of rehabilitation, shown rehabilitation after some period of time. Very different from, and you spoke about this, Ed, different from having a record of that may include arrests, charges, and so on. It is the actual conviction that becomes the automatic disqualifier in this instance. That does apply to both, to all employees, including service employees. But if the conviction is 10 years or more, there's the notion that they can show and we can ascertain rehabilitation. And I think that's a very important message for our stakeholders and people who are watching, because I have also seen anecdotally and heard the misconception that in order to be an employee, you need to have a clean quarry, and it's really the conviction that becomes the automatic disqualification.
For certain things.
For certain things, right.
Not any quarry, but for certain things.
Right.
In fact, let's just read it to say we're,
You want to...
yeah. To be clear, relative to criminal record, the statute says you will be denied. One section of the statute says you will be denied if you've been convicted of a felony or other crime involving embezzlement, theft, fraud, or perjury. It's not any quarry record. It's a felony or any other crime involving embezzlement, theft, fraud, or perjury. there's a question about how you could read that. Does it mean felony and any felony and all other crimes that involve embezzlement, or does it mean a felony involving embezzlement? But be that as it may, we'll get to that. So that's what we're talking about. It's not just any quarry, it's a limited, it's big, but it's a limited criminal background. I think we have some people I know we have some people who are out of town. I don't have any formal sign-up sheet here. Did you want to make any introductory comments? Okay. Mike Mathis, I see back there as the senior representative that at least whom I know from Springfield. Is there a group that wants representatives who want to speak, or do you want to speak, or how do you want to handle this?
Thank you, Mr. Chairman. Good morning, everyone.
Good morning.
Morning.
Good morning.
I think the process outlined by Director Bedrosian makes sense. I think we'd like to come back in May and have a more robust conversation. We're really here to listen at this point.
Okay, fine. Well, does anybody want to sort of introduce their viewpoint? I've taken the time to try to really lay out carefully how I'm thinking about this, but I'll defer to anybody else if anybody else wants to go first, so at least put on the table what I think the issues are.
Let me do this. Maybe you were thinking about touching on this or not, and maybe for our upcoming conversations, this is a question I have of Mr. Mathis and our own staff. I understand that at least from the very limited experience that we have, limited in terms of comparison, we have a big experience with PPC, but there has only been a handful, one service or service employee denied registration because of a criminal conviction. And you've done, even though there's 500 plus employees at any given time, it's a multiple of that because there's enough people that come and go in the period so far.
Almost 750.
You've licensed or registered about 750.
No, that's just registered.
Registered 750. So if you've licensed many more. And you can get back to me on this. The point I'm trying to make is that maybe data is also
Yes.
something that we could use to frame the issue. What you may have seen in other jurisdictions, in your recent example, in your recent opening of National Harbor, what might be the amount of instances that we may be that you may be thinking may happen in Springfield and surrounding communities relative to the number of employees that you expect to make offers, etc. Just getting a sense of those amounts would be really helpful for our discussions.
Yes, Commissioner, I think data is so important in this discussion, as well as the analysis of the statute. And I think one of the challenges that we've all collectively wrestled with is access to the data. And some of what we're talking about today is really what are we going to experience a year from now. And in a year, it'll be, in a lot of ways, too late to come back and remedy, because of the volume, because of the timing, some of the concerns that we have now. So we're being proactive. We'd like as much optionality, of course, as we can have. We do, as MGM, as an employer, I think as dictated by federal law, EEOC, ban the box, et cetera, we do a job relatedness analysis when it comes to these issues. So you've got the employer's own threshold review. So I think we've done some what I call desktop analysis of what we think the demographics of Springfield, Western Mass, Holyoke, some of the gateway communities. And as you know, unfortunately, much of the criminal statistics follow poverty, high school dropout. Those are endemic in some of those communities. Those are the very communities that we believe the statute was intended to benefit, which is partly why MGM chose that location. But some of our analysis is that the incidence of felonies and theft-related misdemeanors are going to be 2 to 3 times what the average is across the Commonwealth. That's imperfect because we're looking at only certain data related to incarcerations and state and county information that's publicly available. But I think it's going to be significant disparate impact. Now, I know everyone collectively is sensitive to that, and that's not the only consideration, but we're very concerned that there's going to be a very practical impact in our local hiring, recruitment, targets, commitments, if we don't collectively find a way to resolve this.
Right. And to the extent, I'm sorry, to the extent that we could also tap on colleagues around the country, the Michigan Gaming Commission, I know you speak to them every now and then, and others, Pennsylvania. If there could be a conversation relative to what they experienced, and I know there's a chart here that outlines the differences between jurisdictions, but if we could get a sense as to, given their requirements, what pool of applicants did they end up not licensing, et cetera, relative to their population and demographics, I think it would be also very helpful. Detroit might offer an example that may be comparable in some areas, and you operate there. So.
I think one of the most important pieces here that I've heard today is the talk about education and what's a real barrier and what is not, what is a real disqualifier and what is not. Having had a lot of experience hiring a diverse workforce, trying to make it more diverse all the time with the police organization, lots of rumors about why you can't get in, and to really work with people so that they understand what's real and what's not. That breaks down some of those barriers, and it helps with folks that would otherwise deselect. They're not comfortable, they're not confident, and they're not going to continue in the process because of what they've heard, and some of what they heard was not true. So that, means being a more welcoming, and I really like the work that RIEB has been doing and licensing on having meetings, talking to people about what is real and what is not, and kind of encouraging people. I know just listening to different investigations that have been done, how we have assisted folks with a hurdle, taking that extra step to make sure the person was able to clean up a piece that may have caused a problem with a license or a registration. So I like that approach. I think if we could do more of that, that could be helpful in these investigations.
To Commissioner Cameron's point about the
Cameron,
educational
Is your mic on?
Your
Yeah,
mic.
it is. The educational component, one piece which stakeholders might want to consider including in that messaging is the ability to seal records. It won't apply to a felony within the last 10 years, but those misdemeanor offenses that the chair mentioned of crimes involving embezzlement, theft, fraud, or perjury. The commission made a decision in their regulations that matters that have been sealed are not to be considered by the IEB in the registration of the licensing process. That's a particularly strong tool for the community if they want to work with members who have maybe have something in their background but may be able to get it sealed and then may be able to work at the casino. So that's something we should just include in the discussion.
I would echo what Commissioner Cameron said. I think there's, I had the opportunity to go out to Springfield to one of MGM's Skill Smart session. I'm giving an anecdotal example here, but a woman approached me who asked me if something particular in her background would make her ineligible. I didn't want to become a lawyer on the spot, but I followed up with the individual. I say stay involved in the process because I think what she had read is probably not based on what the statute says. I think in this intervening period, I know MGM has talked about doing work with the community to go through those type of record sealing educational sessions. I think that's helpful. I think, we as state employees have, the opportunity or the ability to call the State Ethics Commission, when asked to speak to the attorney of the day to help us clarify some questions. I think we should revisit or think about finding a way for the MGC staff to have a similar kind of referral or response role to help address questions that an individual might have. So I think in the intervening period, even while we're still collecting some comment and feedback on the recommendations here, I think we need to kind of revisit what more we can do on the education side, so that, to Executive Director Bedrosian's point, we've talked about this, that people aren't self-selecting out of the process.
Can you repeat again the notion of the sealed record, Karen? If somebody with a criminal conviction
Correct.
within 10 years, within the
Well,
last 10 years,
Right, it won't apply to the felonies, but for misdemeanors, so
For
those-
misdemeanors.
For those misdemeanors on the crimes involving embezzlement, theft, fraud, or perjury, there is an opportunity to petition to have that record sealed, and that happens, so.
even if it's less than 10 years old?
Correct,
Okay.
and even if it's a conviction, as opposed to a continue without a finding or pretrial probation or dismissed, even a conviction can be sealed. There's a 5-year look back
A 5-year look back for the
for the misdemeanors.
misdemeanor.
Which would have been a disqualifier if in fact that record wasn't sealed.
Understood, which is very good.
And it's important to note in this respect that our Supreme Court has fairly recently actually revised an earlier decision that I was personally involved in, that established a very burdensome standard for obtaining the sealing of a criminal record. And without going into the details, it was the primary consideration which the SJC in I think it was 1994 placed significance on was the First Amendment interest and the access of media outlets to the records of conviction, and that the result was a very high burden that anybody seeking to have their records sealed had to meet. That has now been revised, and it's revised in part explicitly with the court acknowledging the unfair and unfortunate prejudice which people can endure on account of just the impact of a single conviction of a criminal offense in the past. So our Supreme Court has, in effect, encouraged a greater access to the sealing provisions of the statute. It's very significant. So I would underscore the importance of an educational component to the people who are interested in working, who might be burdened with a conviction that could get sealed.
Yeah, wherever we come down on this, I think the education and criteria and strategy is going to be very important. We even go back to our community college partners. It can start early on in the process. So wherever we come down, that's a really important criteria. Okay, I have been one of the ones
Sorry,
who's...
Mr. Chairman,
Sure.
because
Yeah.
I sense you're about to
Yeah.
discuss some of your comments. I just wanted, because I would be remiss not mentioning a couple of the folks that came out with
Oh,
us,
okay.
if I could. And then one other comment is, as we spend the next 30 days, because I think it makes sense to come to Springfield, I think we have our quarterly report at the end of May,
May
and to have
25th, right.
and have a robust discussion with our stakeholders. Because even if the decision is not one that we would all like, I think there is some benefit for feeling like we all got our comments and thoughts on the record, and I certainly think it's important that our stakeholder partners are able to do that. But the one comment, our reservation I'd like to try to place on the record is that as we review the data and the policy over the next 30 days, recognizing that there's been a recommendation on the legal opinion of staff, we'd like an opportunity and hope is still an open issue as to what the commission feels are their legal rights under the statute. For example, I know Commissioner McDonald mentioned in his memo that his view was slightly different than what I'm hearing the staff's view, which is that there's a conflict, and when there's a conflict, discretion can be exercised. This statute, as much as I knew it, I learned something upon every new reading.
Right.
And over the last 48 hours, as we've gotten ready for this discussion, we've learned new things that I think are potentially compelling arguments if the commission is looking for an opportunity to exercise that discretion, not necessarily the fact-based discretion that I know concerns the staff in terms of administering this, but I think the discretion to potentially create this class, this service gaming class that might be completely exempt.
Right.
So if we can, I'd like to be able to respond to some of the legal arguments and show you some of the work
Yeah.
we've done.
That's absolutely on the table.
Great, thank you.
No question.
And then I just want to acknowledge the folks that came out with this, and there'll be more that will be participating in May. But we've got representatives of the Mayor's Office, Urban League, NAACP, Habitat for Humanity, as well as Friends of the Homeless. And many of them have shared with me anecdotes, because I think part of this is to put a human face on some of the theoretical discussions we're talking about. And there's some really compelling anecdotes for the candidates that we think we'll see that would be really shameful to automatically disqualify. So if we can have an opportunity to have those discussions in Springfield and do some work in between, I think it will make for a much better discussion.
Well, we definitely, I think, will anticipate that. I know our agenda for the 25th is a very busy agenda, so I don't know how much room there'll be to have many people come and speak, but we can talk about that, and maybe some people can submit in writing during the previous month, and you can help select out leaders, but there very much will be an opportunity for that, and it will be on both scores. It will be on the legal issue, discretion or not, as well as on the implementation and the policy discussion. Okay, so I want to just sort of take the time to lay out what I think the issues are and what's driven me in my wrestling with this. And although I've pushed this off and on now for months, I don't feel emphatically clear where I come down yet, and I'm really interested in hearing other people's comment over time. But just to make sure everybody understands, there are 4 categories of people whom we essentially qualify to work in and around the gaming establishment. The first is people involved with the license holder itself, the casino license holder itself. That's the highest level of personnel. That means Steve Wynn, who runs Wynn Resorts, and Jim Murrin, who runs MGM Resorts. Those are gaming people involved in the gaming license itself. The second, but I'm not going to get it. Just think of 4 different categories of whatever our terms of art we are, you know. So one category, the highest category, are the personnel involved with the casino owner itself. Second, we call key gaming employees. That means Mike Mathis, the president of MGM Springfield, or Bob DeSalvio, the president of Wynn Everett Resorts. That's high-level, key gaming employees. The third is gaming employees, people who are involved on the gaming floor, essentially, and in gaming operations, but they might be card dealers or pit bosses or techs, I guess, slot techs. That's called gaming employees. The fourth category is what we call gaming service employees, or we also sometimes refer to them as non-gaming employees. Those are people who will work in the hotels, the restaurants, the retail establishments that are part of the gaming establishment but not integrally involved in the gaming itself. So gaming licensees, key gaming employees, and gaming service employees. Now, Section 16 of our statute is the definitive section in setting out the kind of high-level parameters for what will disqualify those categories of people, Section 16A and Section 16B. Section 16A refers to, again, I'm just colloquial language, refers to the automatic disqualifiers for the two highest levels, the gaming licensees, the Steve Wynns of the world, and the key gaming employees, and I want to read it to you. The Commission shall deny an application for a gaming license or a license for a key gaming employee issued under this chapter if the applicant has been convicted of a felony or other crime involving embezzlement, theft, fraud, or perjury. 2, submitted an application for a license under this chapter that contains false or misleading information. 3, committed prior acts which have not been prosecuted or in which the applicant was not convicted, but form a pattern of misconduct that makes the applicant unsuitable for a license under this chapter. Or 4, has affiliates or close associates that would not qualify for a license or whose relationship with the applicant may pose an injurious threat to the interests of the Commonwealth in awarding a gaming license to the applicant. Those are the 4 overarching, most important criteria which are automatic disqualifiers for the owners of the casino and the key gaming employees. Section 16B applies to gaming employees, the lower level gaming employees, and gaming service employees. And the standards written in our statute are exactly the same, except for those 2 categories might have an opportunity to rehabilitate if a crime that's been they've been convicted of was 10 years or more prior to the time of the application. So this statute it does set out the exact same standards for Steve Wynn as it does for the person who works in the restaurant, except that the person in the restaurant, if they committed a crime 10 years ago, they have an opportunity to be rehabilitated. That's what that says. Now, if that's all that was in here, we wouldn't be having this conversation because it's black and white in what that says. If there were nothing else in here, I would be saying, does that make sense? Why on earth would they ever, why would the legislature ever have set out the fundamentally exact same standard for Mike Mathis as for somebody making beds in the hotel? But that wouldn't be my problem because that's what it says. However, we then get to section 30, which basically, and by the way, just for the record, this is me talking. This isn't, nobody has to agree with this necessarily. This is how I have come to where I am on this issue. Now you get to section 30, which essentially directs the implementation of section 16. And it applies there are 4 sections that applies to the gaming licensees, the Steve Wynns of the world, and to the key employees. Section 30B requires that those 2 categories of people file an application which includes a criminal and arrest record. It does not have that requirement for gaming employees or gaming service employees. You are not required to file an application. You are not required to submit a criminal or arrest record for a gaming, even though supposedly in section 16 you're subject to the exact same automatic exclusions. Section 30D requires that for Steve Wynn and Mike Mathis, that the commission shall conduct an investigation of those 2 categories, including fingerprinting. It does not say that about gaming employees or gaming service employees. Again, even though section 16 says they're supposed to be held to the same standard. Section 30G sets out an appeal process from this investigation and the background check for key gaming employees and gaming licensees, Steve Wynn and Mike Mathis. It sets out an appeal process by which if you are not permitted to get a license because of one of those automatic disqualifiers, you can appeal it. There is no such thing. There is no appeal process for gaming employees or for gaming service employees. Section 30I sets out fees and terms of the license, lengths of license, the authority for us to impose fees and the term of a license for casino owners and for key gaming employees. It does not say anything about fees or terms for gaming employees or for gaming service employees. So I look at that and say, wait a second, that just does not make any sense. If section 16 means that the criteria are identical, except for the 10-year rehabilitation possibility for the offense, for a criminal offense, why does Section 30 not require that the commission do the same things? Get an application, get a criminal record, get fingerprinted, have an appeal process, set fees, set terms of what a license, how long a license should act. So I see this, that raises to me a huge question about what the legislature was thinking. Are these internally reconcilable sections? Then we get to 30F, which has caused all of us the most trouble, I think. 30F says, whereas Section 16 says the commission shall deny a license if there are any of these 4 criteria met. Section 30F says we may disqualify an applicant for one of those violations cited in Section 16. And furthermore, it says we may permit rehabilitation of any of those people in those categories with no respect to a 10-year term. Now, that is flat out incompatible with the language in Section 16, as I see it. I mean, you just cannot make sense of those two things. I can't make sense of those two. Maybe some, I mean, I know there are people who can. So again, this is just me talking, but it is simply does not make any sense where one section says shall and one section says may for the exact same circumstances, and where there is an absolute 10-year bar in one section and ignoring the 10-year bar for rehabilitation in another. So that's what I see as I read these things, and I see more every time I read it too. And again, I'm mindful that, not everybody agrees with me on this, but for me, this raises a series of questions that gets to the conversations we're going to be having over the next month. One is, in my mind, is clearly confusing. I mean, I just don't see how anybody could read these two sections and say it isn't confusing. And as Commissioner, Executive Director Bedrosian said, and as Commissioner McDonald has said, where there is confusion in a statute, an agency, an administrative agency has discretion to try to reconcile confusing language as best it can, understanding whatever the broad-based policy objectives of the organization are. 2, Section 16 holds the suitability standards for the Steve Winds of the world as the same standards as for hotel workers, and that just doesn't make sense to me. Is it possible that that's really what was intended? Maybe it was, but I asked that question, is it intended? Except for the issue of the 10-year rehabilitation period, otherwise exact same standards. In my mind, Section 16, as it is written, is clearly, and as we've implemented, and I was a part of that implementation, we all agreed to implement it the way we did implement it. And as I see it, Section 16, as written and as implemented by us to date, is a barrier to employment opportunities for some of the people whom we are most targeting in this act. We specifically talk about unemployed in the act. We specifically talk about bringing the benefits of the casinos to the broadest economic spread of people as we possibly can. I see this as a barrier to that issue. And finally, because it is, I see a legal and a policy question about whether the legislature could have intended to single out a class of people, because inevitably people who are going to be affected by this are going to be a certain demographic class. There's going to be more people of color, more low-income people, and so forth. They're going to have a barrier to employment in these kinds of jobs for reasons which don't have, in my view, any nexus to the jobs. If you're a bank teller and you've gone to jail for embezzlement, I get it, that's a problem. If you're working in a hotel, restaurant, or in the changing beds, is there a nexus between that criminal offense? And I think there are subtleties to this, but I think there are legitimate legal and for sure policy questions about whether or not we have been applying this in a way which is compatible with the principles and spirit, if not letter, of EEOC type rules and regs. So putting that all together, it's inherently conflicting. I can't rationalize how the legislature could have come down where they seem, in some senses, to have come down. I do think we have the discretion to talk about it. Where we come down will be up to the 5 members of the commission after we eventually hear from all of you. But that lays out, for my purposes, what brings me to this conversation. If anybody else wants to put their 2 cents worth, please.
Yes, Mr. Chair, many of those thoughts are compelling, but I keep coming back to the fact that we are the regulators, not the legislators. And, in my mind, many of these things would take a legislative fix, frankly. And I think we are fortunate enough to have an attorney on staff who, this was the kind of work she did. She interpreted at the AG's office, made sense of policies or statutes that conflicted, and I know has spent some time. I, for one, would like to hear from Attorney Lilios on this matter in how to distinguish, how to make sense of statutes that may look like they conflict. I would be very interested. I know that that's her background, so for any of us to think we have more experience or can interpret it better, I think I would like to hear and just get that knowledge from someone who actually worked in this field and did this for a living.
So I do have some comments that I am prepared to make, but with a caveat that nothing that I have to say has any bearing on any policy considerations or the questions that you raised, Mr. Chair, about whether it makes sense to have a WIN executive the same as a hotel employee, or the desirability or the non-desirability of any changes to the legislation. So my comments are not focused on those areas.
Mr. Chairman, I think in terms of trying to frame the issue and get the commission as much information as we can, a ping pong match right now might not be the best solution. I think that you've raised some thoughtful interpretations of the law. Obviously, Mr. Mathis said they have a new interpretation of the law that we hadn't heard about recently. So both Ms. Lilios and I have a background in administrative law. That was part of what went into our analysis. Perhaps it wasn't as deep as it could have been. I mean, we can share that. But I think at this point, the benefit might be, I don't expect there to be resolution on this issue today at all.
I was partly meaning, we have a memo from you and the staff that all of you contributed to, which I thought was sort of your definitive view on where you are at this issue. And I wanted
It is. Having said that, we've now heard things, obviously, to which we might want to respond.
Yeah.
I mean, your interpretation, I could respond to.
Yeah.
I'm not so sure going back and forth with staff in the commission right now is going to be as beneficial as sitting down with MGM and perhaps, as you framed, obviously, a very broad issue on your interpretation of 16. But I can't tell you, my gut just tells me I'm concerned about a ping pong match right now.
I get you, but I'm reluctant not to have any one of the commissioners feel like there's not been a fair two-sided conversation.
Well, that's what I'm feeling like. I think the memo just broadly outlines
Yeah.
where there are specific ways that I've learned that to try to make sense of these issues that we have to pay attention to. So we did hear kind of one side of the ping pong match, and I would be interested in hearing. And again, this is not in order to debate everything here, but just to give us more information. These are important decisions, and I think hearing this is an important piece, and I know there'll be
Yeah.
more in Springfield.
So let me set the stage, and then I'll turn it over to Ms. Lilios, who will make the appropriate arguments, because I know her. It feels like the law is very clear, and people may disagree with that. That, as you said, the Steve Wynns of the world, the qualifiers, have to go through the same type of scrutiny under Section 16B as the dishwashers. Yes, although there are other considerations for qualifiers. 16B, as I understand, doesn't set out all the qualifiers expectations. So it's not,
It's
it's
section,
not,
section 12 too.
Right, so
Section
it's-
12 gets incorporated in too.
I get it, but it's not, my message is, it's not a direct analogy that Steve Wynn and the dishwashers go through the exact same process. That's not the exact same process. It also feels like you have to turn yourself into a pretzel to find a way out of registration when the language is so clear. Again, not agreeing with the policy of registration of these folks, but looking at what the legislature intended. So I look at a plain reading of statute. I understand there is the may component of Section 30F can be confusing, but I think there are some criteria of Section 16 that are somewhat subjective, that refers to. There is some discretion within the IEB as opposed to some of the black and white considerations, which I think the criminal disqualifiers are. So having said that, let me ask Ms. Lilios, who also worked in that division on a daily basis and wasn't just someone up top reviewing the work, if she has any thoughts on that.
Well, before she presents, just for the record, we have in the packet, which is available to the public,
Sure.
your memorandum, and
Sure.
on this issue, is it not accurate to say that the staff did not reach a consensus on this particular legal issue?
Absolutely. These are that was my opinions, absolutely. You're absolutely right, Commissioner.
You know, there's some things that you did reach consensus on, and one of them was that there, if I understand it right, is that the statute is not ambiguous about the requirement for registration of all employees, service and otherwise, correct?
That is correct, sir, yes.
Yeah, and I actually think to a certain extent there's a certain benefit because we do have an audience here who I know is invested in this issue, and it'll give you some sense of what we're wrestling with, and maybe help us when you're commenting on this over the course of the next 30 days. So.
I think we just really want to be respectful of, I don't want to create a situation that's, we're not being helpful in the discussion, I guess is.
Agreed. I think the information you have could be very helpful, frankly. I mean, I've had conversations with both of you about this to help me understand it better, and I think those conversations in public are important to help us understand how complicated this is, but also, how these things are read, and there are good reasons why, how you make sense of two that may appear conflicting statutes. So I for one, would welcome some of that expertise.
Okay.
Okay, so this is a little bit more awkward than I thought it might have been initially, but, so I have given some thought to the interplay between Section 16 and Section 30F for some time now. And even before I started with the commission, when I was an Assistant Attorney General, I was serving as a special advisor to the Attorney General's office on the then newly enacted gaming legislation. And I have a background in statutory analysis, so I have a laser focus on permissive language in the statute versus mandatory language in the statute. Essentially, I'm trained to look out for the mays and the shalls. And I first of all, want to say that in my experience, 23K and our even the expanded Gaming Act is a very well-crafted piece of legislation, and the legislature should really be commended for the clarity and consistency. It's a statute that was a huge undertaking, given how comprehensive it is and covers the bidding process, the award process, the licensing process, background, community mitigation, casino operations, the research study, exclusion, and so on. And it's in stark contrast to some other statutes that I have experience in, and with all due respect to the legislature, I've had the opportunity or the misfortune maybe to have been involved with other pieces of legislation that were rightly subject to challenge on constitutional and other bases. And I was on the front lines when the Commonwealth enacted community parole supervision for life, and I tried one of the first cases in the Commonwealth on some other major pieces of legislation that were then challenged in the Supreme Judicial Court, and I handled and supervised those challenges, and resulting in the SJC striking down portions of legislation and the legislature having to go back to the drawing board. Same as Ed referenced in the Attorney General's office, I represented agencies in the Superior Court and the appellate courts. And in all of those cases, statutory interpretation was at the heart of the dispute, whether reconciling provisions of a federal statute and the state counterpart or in other areas. And mercifully, 23K is a picture of clarity when compared with some of those other pieces of legislation. But back to Section 30F and 16. So there's been, all this discussion about the tensions between 30 and 16. And when reconciling tensions in a statute, thankfully we are not left to our own devices to figure it out on our own, but the courts have given us a roadmap to resolve tensions or ambiguities in a statute. And this area of statutory interpretation or statutory construction is one area where the courts are in agreement. So the United States Supreme Court and the federal courts and our own Supreme Judicial Court are in agreement on the principles that apply in this area. And so applying those principles, if we see an ambiguity in a statute, we are first required to look at the intent of the legislature. And here again, we are lucky because the legislature in 23K explicitly said that the paramount objective is integrity in gaming licensing and a strict regulatory oversight, and also explicitly said this is a job creations bill, particularly for the unemployed. So we know what the intent was. These principles also tell us that we must read the statute as a whole. We cannot read a provision in isolation. These principles also tell us that we must assume, and this is very difficult to do, but that we must assume that the legislature meant what it said, and we must give meaning to all provisions in a statute, unless to do so would be nonsensical. So we can't say, really the legislature meant to say shall if they said may. We must accept what the legislature said, and we must, and Ed referred to this, the overarching theme is this theme of harmony. We must harmonize various provisions of a statute, recognizing that the legislature did not intend internal contradictions in a statute. If a sensible construction is available, we must accept it, and where a conflict exists, the more specific terms in a statute prevail over the more general terms. So applying those principles to 30F and 16, we see, in covering some of the same ground that you covered, Mr. Chair, is that Section 16 sets out the grounds for denial of applications and registrations. And Section 16 sets out very specific information about the disqualifiers. 16A talks to the 4 mandatory disqualifiers for the 2 categories, the keys and the gaming licensees. The first disqualifier is the certain types of criminal convictions, and the remaining 3 disqualifiers are for falsity on the application, pattern of misconduct behavior, and associational issues. 16B then sets out the disqualifiers for the lower level of employees, the service employees and the gaming employees, and as you noted, the disqualifiers in 16B match word for word the disqualifiers in 16A. However, on the criminal disqualifier, that one of the four, those lower level of employees have the opportunity to demonstrate rehabilitation if the conviction occurred 10 years or prior to the application. So in that area, we see explicitly that the legislature made some accommodation on the employment side of their intention for these lower levels of employees. So turning then to 30F, the first clause of 30F addresses all categories of employees with the same language. It says the commission may deny a license or a registration for a key, a gaming employee, or a registrant if the person is disqualified. And then the second provision of 30F goes on to mirror 16B's rehabilitation component for service employees and gaming employees with 10-year-old or more convictions. So we are left to determine, does the may language in 30F give the commission discretion to grant a registration to a service employee with the disqualifying offense within the 10-year period? So applying those principles of statutory construction in my analysis, which again is not policy directed, but applying those principles, if we interpret the may to give the commission the discretion, we would have to ignore the plain detailed specific language of 16B as it applies to service employees. And ignoring language is something that we're not supposed to do under the principles of statutory construction if we can harmonize the two, because we have to accept the legislature wanted to give effect to every provision. If we select out from Section 30F service employees and subject them to this discretionary treatment by the commission for the criminal conviction disqualifier, but leave in gaming employees and key employees, we are reaching a nonsensical result because the statute simply does not say that. It treats all categories the same with respect to the may language in Section 30. We could, however, harmonize the two provisions by viewing the may in Section 30F as a grant of authority to the commission to deny a license or registration, rather than as a grant to exercise discretion with one category of employees, service employees, and for one of the four categories of disqualifiers. This, in my view, is the way to read the statute as a whole and harmonize and give meaning to both provisions as we are required to do. Now, Mr. Chair, you also mentioned something with Section 30C that I'd like to address. You talked about how Section 30B gives this whole litany of things that keys and gaming employees have to provide in their application form.
Gaming licenses and keys.
Correct. And then 30C talks about gaming employees and, service employees required to register and shall produce information as the Bureau may require them to do. So it doesn't give out the whole litany. There is a harmonization piece there as well, which can be found in the way the regulations are currently drafted, which allows that service employee to get to work first, and a background to be performed on them at a later date with information, as the statute says that the Bureau requires to see that these other provisions of 30 and 16B are fulfilled. But in any event, in my view, this analysis is in keeping with the balance of purposes and the statute's dual goals of integrity and as a jobs creation bill. And now I recognize that as Ed referred to, that courts give broad discretion to agencies and would to the commission to interpret and implement its own enabling registration. A reviewing court would, if a court reviewed the commission's actions in this area, a reviewing court would apply these principles of statutory construction that we've been discussing under the framework of allowing an agency, broad discretion. But those principles would be applied.
Thank you. Loretta, can you go back to your conclusion on the harmonization piece? I think that was key, and I want to make sure I jot it down. How do you reconcile the two sections, 30 and 16, and that may effectively gives us the discretion to issue a license?
Well, that is, if you view the may as it's a discretionary may, then we're in a difficult position, because then you'd have to be saying, well, we have the discretion to give a license to one of the categories, even though in
It talks about
30,
the four.
everybody's all mixed together. And we have the discretion on one of the disqualifiers for one of the categories, even though there's 4 disqualifiers. And to me, that's a stretch. But if you interpret the may as, this section is section 30, it's a more general section on the licensing process, as opposed to section 16, which is very specific, speaking about
disqualification.
disqualifiers. So if you view the may in 30 as, this is your grant of authority, you may deny it. You have the authority to deny it. And then coupled with what we must deny in section 16, that was how I viewed, you could read both sections together. You wouldn't have to say, we have to cross out one of the sections, we're just not going to give effect to it.
Right.
But again, I don't.
You're distinguishing between the granting, which is permissive, and the denial, which is mandatory. In reading these two, is that a fair summary?
I'm distinguishing between a grant of authority to deny a license with a grant of discretion to decide whether to deny or allow a license.
Okay, thank you.
So just to clarify, and I think Commissioner McDonald hit on this point, we didn't have unanimity. We didn't really address this issue as staff with unanimity like we did the registration, flat-out registration requirement, part of which, because I think what we did agree upon is the grant of authority, if interpreted in Section F, came with a grant of authority to engage in a rehabilitation analysis for people convicted within 10 years. And given the context, which I think I referred to earlier, of trying to register 1,200 service employees for MGM and potentially 2,300 service employees for WIN within a 90-day period, at the same time doing all the, as you referred to, Mr. Chairman, all the higher level actual analysis we had to do seemed unworkable. So I think what you heard from Ms. Lilios was based on her background and her experience, but wasn't, at this point, a unanimous position of staff, because we didn't sit in a room and come to a conclusion on that.
Because you didn't think it was necessary, because you didn't think it was workable.
Well, we thought that obviously this issue of getting to a rehabilitation analysis was, unfortunately, given the context of all the other things we have to do, was unworkable, quite frankly.
I think that's an important point for people to understand, and that is that as I read this staff memorandum, that you basically identified that you couldn't come to an agreement amongst the legal staff, but that it kind of doesn't make any difference, because if 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 you concluded that the commission did have discretion to apply these multiple factors to determine rehabilitation, inasmuch as the IEB is going to be faced with literally thousands of prospective employees, there's no way in the world that the commission staff could accomplish that and be faithful to the larger objectives
Exactly.
of the Gaming
Right.
Act. So I viewed this, and I found it convincing, is let's just take that, we don't need to fight about this particular issue. Let's focus on whether or not, on what remedies might be available, and you listed those out.
Right, exactly, thank you.
I'm remembering attending really early on a gaming policy advisory committee meeting where this issue was talked about, and there was even then, and as I suspect there might still be, disagreement as to the intention of this topic, even among members of the General Court. One of them talking about in that, and also a member of the GPAC. I'm wondering if it's worthwhile to try to ask the legislature for some clarification in this topic, or is it just really not a good time, given that the budget process?
I'll turn it over to General Counsel. I suspect what you would get back is see Section 1.
We did a legislative history search on it, and there were differing ways that this section was drafted, and there were roughly 13 bills that eventually became the Expanded Gaming Act. There is no legislative history on it. There are things that the legislature changed, which I have been advised by judges in oral arguments. What ends up at the end is what counts, not what the changes were. The fact that something's not included in a particular bill does not mean something else was rejected or accepted. So there is no good legislative history. If you ask a particular legislator, they may have an opinion on it, but there is no, good legislative history that says this was what they meant or this is where they were going.
And we were advised by the Senate President's office that if we wanted to get, if we were on other places, we were trying to figure out what the legislature was intending, and they said you can ask the Senate Counsel office, don't call up the legislators and ask them what their intent was.
Well, I was meaning more of along the lines of technical corrections, whether these could fit under a technical correction. But given all the discussion, it sounds like
I think this
it
is
really
pretty
is.
complicated, so it's much more than a technical correction.
It really, okay.
Okay, yeah, please.
Mr. Chair, thank you for allowing me to make an additional comment, and Executive Director Bedrosian's fears of the ping pong match have been realized, because I feel compelled to give you just a preview, and I find this, as a geeky lawyer, former geeky lawyer, some of this is intellectually satisfying, because even some of the arguments that I've heard today, despite an exhaustive review, are new to me. But I wanted to give you a preview. We haven't had the benefit of looking at the memo, which we will do, and some of the other comments, but I wanted to give you a preview, because I think our sense is that if, and I don't want to speak for the commission, if 16B didn't compel what you feel like it compels, then there's many other provisions and many policy arguments to allow for some discretion on non-gaming employees. And we have a read of 16B that we think allows for that. So what I point you to is the definition of applicant, which I think is, we talk about the provisions, but we don't necessarily talk about the meaning of the words. So if you go to the definition of applicant, an applicant is a person who has applied for a license to engage in activity regulated under this chapter,
Interesting.
not a registrant.
Got it. I hear it.
16B sets forth a series of automatic disqualifiers for applicants. So we believe that there's a reading of 16B that if you use your 4 tiers, 16A is owners and key, and 16B is just gaming employee, and it allows for a discretionary discussion, a different set of considerations, logically, as you pointed out, for registrants.
Yeah.
If I could add one point on that, Mike, because there's, and I'm sure folks are aware of, there is the word registration in 16B, but it talks about in terms of an applicant. There theoretically could be an application for registration, because when you look at 30C, that gives broad discretion to the commission to set up a registration process, it has this category of people who are not key gaming employees, they're not gaming employees, but they have access to areas of the gaming establishment who can't fall under 30C. Those are something that's a new category. And that could be an applicant for registration that's something different from a registrant that doesn't need to go through the application process under Section 16.
Yeah, interesting. Okay, well, I think we've all heard stuff we haven't heard before, which shows how complicated this is. Those of you who are interested in participating in this conversation the next month, you know, anecdotes are interesting and but not as persuasive as data and as legal analysis. So if anything you can give us, anecdotes have a role, but data and legal analysis will, I think, be more persuasive to us as we try to wrestle this to the ground. Did you have a? Yeah, quickly. Can you hear, Mike? Can you hear?
Just identify yourself, Jeff.
Take it, Mike. Thank you very much, Loretta. Mike.
Jeffrey Boyle Community College in Massachusetts Casino Careers Training Institute. Say that twice fast. Thank you for the opportunity. I'll be very brief. We will have some data that we'll present to you at the May meeting. We actually take data on this issue, especially for those entering any training program. And right now, there are two categories that are important to know. One is the number of people within training programs who have an issue, and usually it's 2 or 3 a class. So if the class is 15 people, then it's that amount. The other category that is actually more frightening to us, because it's all about building the workforce for the industry in Western Massachusetts, is the number of people who don't even show up at the door because they have a quarry issue. We estimate about 30% of those who inquire about the training program do not enroll or drop out after enrollment because of quarry-related issues, conviction of a felony, or those other misdemeanors that you mentioned earlier, Mr. Chairman. So we'll have the specific data for you, but that's a sample of about 700 people who've taken workforce classes. It's a fairly large pool of people who cannot participate yet in the opportunity for jobs. And I think the piece that I like to remind folks of is that we're at a perfect storm in Western Massachusetts. We've got some great development activity. MGM is a great example of that that's going on. But we also have in our suburban communities extremely low unemployment. In our cities, we still have challenges with employment, but those challenges are people who have been out of the workforce for a long time. So long-term unemployed, long-term underemployed, people with low educational attainment. So getting them ready for the workforce will take some time and work and effort, and this obstacle related to their criminal background is significant. So I'll get more data to you.
A quick question, Jeff, and thank you for your help. I think one of the things we have been struggling with is finding data, but the 30% you talked about who inquire about a program, they're inquiring about your culinary program?
At this point, it's for all of our workforce-related programs. So whether it's healthcare, manufacturing, that's about 25%. For hospitality and culinary, it's 30%.
Okay. Thank you.
You heard the earlier discussion, Jeff, about educating people. With this 30%, are there folks there that maybe could have a record sealed and be eligible, but they're not aware of that option? I mean, how?
I think there are a fair number of those. There are some people who opt out without really knowing what the legislation says.
So would it help?
Education would be useful.
Okay.
I think, though, that it's still a significant number of people who are excluded in a very limited labor pool.
In a very limited labor pool.
Right. So there are approximately 10,000 people in Hampshire and Hamden County that are unemployed. And of that population, these are the significantly hard to train and place. These are folks who have been out of the workforce for a significant amount of time. And so, you know, when a company like MGM comes in and says, we're going to hire 3,000 people, where are they going to get the 3,000 people? And even if we account for people moving from existing jobs to a company like MGM, we need to also recognize the fact that we still need to fill that other position. So from our point of view, there's a very limited number of people in Western Massachusetts who are looking for jobs. Everyone's always looking for a better job, but a very limited pool who can go in at entry-level positions and do the work that's required. We're concerned not only in terms of potentially the hospitality and culinary area, but also potentially with the gaming positions themselves.
Thank you.
Thank you all very much for all this, really helpful, and we will look forward to a well-informed next round at the end of next month. Why don't we take a real quick break and we'll come back. Are you done, Director Brodosian, with your item?
You think I could top that? I am done.
All right, we'll be back in just a minute. We are reconvening public meeting number 215, I think it is. And it turns out Executive Director Brodosian has one other topic.
I do. Thank you, Commissioners. Director Griffin had reminded me, she had asked me to make an announcement that WIN was having an update meeting for former and current Suffolk Downs workers. I think Mr. DeSalvio has talked about doing that. And it is this Saturday, April 29th, 9 to 11, at the Hilton Garden in East Boston on Boardman Street. So just in case there are folks watching, please be aware of that. And I know we'll probably...
Say again when it is?
It is this Saturday, April 29th. It's going to be a beautiful day, by the way.
This is for former Suffolk Downs employees who might be interested in working at the Wynn Casino.
Current and former.
Current and former Suffolk Downs employees who might be interested in working at the Wynn Casino.
And learning about the range of
Yeah,
job
great.
opportunities at the Wynn facility.
Great.
Yes. So with that, thank you, Mr. Chairman.
Director Wells, welcome back.
Thank you, sir. So the next item on the agenda under 4A is the licensee outside director background checks item. At the last meeting we had before the commission, you had asked me to take a look at what other jurisdictions do with respect to licensing outside directors of the high-level casino companies, your Wynn's, your MGM's, your Penn Nationals. And we had submitted a chart, which is in the packet again this week, I believe. And then at the conclusion of that discussion, we had put the request out for comment. And as a result of that request, in your packet are some comments from MGM by way of Fox Rothschild, a comment page from Wynn Resorts, something from the American Gaming Association, and also from an individual, Hal Shear. So I believe...
Whom I will recognize is right behind you, the managing partner of Board Assets. Thank you, Mr. Shear, for coming.
That's nice. So I know, Mr. Chairman, this has been a topic of interest to you. These are the comments. I think that the way it's set now, right now, we do capture all the outside directors of all our casino companies, and then the question before the commission is, does the commission wish to make a change in any respect to the regulations that are currently promulgated?
And Mr. Chairman, just one data point, because it might be noticeable. You had introduced this subject, I think, because you had been in an event with Mr. Wilmot, who is obviously in charge of Penn. Penn didn't specifically submit comments, but I will remind you, which I had to be reminded, Mr. Wilmot is a board member of the AGA.
Okay. Okay. Yeah, so remind me of two things. How does the statute, what is the statute? What's our flexibility? I know we have some. I can't remember exactly how it's constructed.
Oh, I'm going to have to get back to you
All
on
right.
that. I mean, I
Okay.
think the statute, I did look at it. I think that in looking at the statute, I did not personally see, and I would, request, if we're going to go down this road, we should have the legal department look at it, because I didn't look at it
Yeah.
to that extent. But I did, when I took a cursory review, I did not see anything that would prohibit making some adjustments
Right.
that some other states have done. But before promulgating any change,
Right.
we should make sure the legal department is on board
And
with
what is,
that.
do you know what the number of the reg is, Catherine, offhand?
I don't offhand, it's not the licensing reg, but the qualifier reg, which is a little bit earlier in the
All
group
right,
of
well,
regs, but we can
find-
check.
Yeah, I'd like to go back and, let's look at that. So, both of you put the issue on the table. Is this something we want to pursue further?
Yeah, I think so. I read the comments with interest. I did not think at the time when we last discussed this, when we were talking about this issue and comparing ourselves with other jurisdictions, and liking in particular the approach by Pennsylvania, which we spoke about last time. The notion of reciprocity, which is also clearly in the statute, and something that a couple of the comments highlight. If outside directors have already gone through the suitability process in another jurisdiction, like many of them have, frankly, that might be an easy tool for us to implement quite simply as allowed in the statute, and take that in consideration. I think my recollection of the statute in this context is that the IEB looks at the whole org chart and determines who is going to be subject for licensure or who is going to be a qualifier, and in that discretion that the outside directors may fall in, which is why I like particularly the Pennsylvania approach, as well as I stated earlier, or even the reciprocity notion.
So
as
you
the
like-
comments.
Commissioner, you like the directors in privately held companies, but
Yes.
not necessarily a public company?
Public, yes. And this clearly applies very importantly to us, because the three licensees that we have are all public companies.
Correct.
But as I mentioned last time, there's a lot that can be gleaned from public information about directors of public companies. There's a lot of scrutiny that is placed by the SEC on public companies. And I think making that distinction is something that would be very helpful in our context.
And I know with the issue of reciprocity, we do use other jurisdictions' information, and it may shortcut our investigation, but certainly not just carte
A blanket.
blanche. Yeah, I know that any investigator would want to not give their blessing until they've at least, and it's the same form, so it wouldn't be like that outside director would have to recreate the wheel. The form has already been filled out for another jurisdiction, and it may just be updating. Say, for example, they were licensed 4 years ago. It may just be a quick update of what's happened in the last 4 years with that individual. So I think, Director Wells, that information is useful and can shortcut, but certainly an update would be necessary if we choose to stay with all
Correct.
directors. Is
Correct.
that
Yeah,
accurate?
For example, you may have hypothetically, you may have an outside director who was licensed by jurisdiction X, but then say that was 3 years ago, but then jurisdiction X relied on jurisdiction Y, which was another 3 years ago. So now you've got stuff that's 6 years old. So you just have to take it on a case-by-case basis and look at what the information is.
That's true enough, but there's also my understanding that is that at least for public companies, these outside directors have there's a rotation, if you will, of outside directors. It's the exception to have somebody with many years,
Okay, that's a good point.
and as opposed to somebody that comes for a term and then leaves.
One option, Mr. Chairman, would be if the commission has a sense that it would like staff to explore the Pennsylvania model, I think we might call it, which was referenced in a bunch of the letters, which I think in the end, has a catch-all discretionary provision for, the type of reciprocity or exclusion, but with the discretion on an individual basis of doing a background. If the commission would like staff to explore that, we would look at our regulations and determine first, as a condition precedent by legal department, that we can do that.
Yeah.
And then secondly, once legal department determines we can do that, we'd give you a red line version of what we think, our input into a sort of Pennsylvania model might look like, and it might frame your discussion once you actually see it on paper.
There are a couple of other things that I think, I definitely would like to pursue this. I think let's keep this going for a while. There are a couple of things that I would like to pursue. We have had now all three of our licensees and one of my college roommates saying this is a discouragement to good quality candidates. But that's that's an anecdote, that's an assertion. And I think it was actually Mr. Scheer suggested that it would be worth going to some of these search firms. And we have major ones here with whom we have good connections who do board searches to see, find out who does casino companies in their director search and hear from the horse's mouth, is this really an issue, or is this, another friend of mine said the benefits of serving on a public board are so great, it's not going to discourage too many people. So I've got different views of this, but I think that would be another place we could get some data. And then secondly, I for one have no idea what the scrutiny, besides the best practice that Mr. Scheer refers to, that a corporate search firm will do a vetting process. I don't have any idea what the SEC, for example, does, if anything. And we don't have to look too far to see that there's a lot of board members out there on SEC-approved companies that aren't doing so well. So I'd be interested in knowing what else there is. So those would be two data points that we could add to the one you described, the Pennsylvania, as we think about this a little more. Anybody else have comments or?
No, I echo that. I'd like to look at this a little bit further. I looked through the comments. I think some of the comments pertain to how difficult it is to recruit board members. I don't think extends exclusively to gaming companies. I think, Sarbanes-Oxley probably put a lot of new requirements on board members from any publicly traded company. I think, so, and to your point, these are pretty lucrative positions that I don't know how much filling out a form chases somebody away. But I'm curious to explore the Pennsylvania model a little bit further, to not be deaf to the industry, to find a way to use the multi-jurisdictional form and the Massachusetts supplemental form, which is not a big piece of paper. I think there's, some easy paperwork hurdles for us to get over. But to take a look at some of the directors that, again, Sarbanes-Oxley, I think and Enrique probably knows more about this than I do, but I think that changed the obligations of directors and changed their authority probably more than any.
It did a lot more on management, but you're right. There's a lot of controls, a lot of relative to audit committees that legislation, puts on in terms of scrutiny of at the board level. I would argue, however, that for qualifiers, the form is pretty onerous. The multi-jurisdictional and supplemental form is can be, especially for somebody that has a lifetime of activity in terms of financial information and so on and so forth. But I think we should, as we're all coalescing here around the notion of let's keep studying the topic. As I mentioned already, I think the Pennsylvania approach is a very sensible one. It carves out the directors that have the most relative to audit findings, internal controls, and the chairman of the board or the audit committee members, and I think that's a great compromise when it comes to these companies.
All right, so is that a clear enough?
I would actually be interested in hearing from Mr. Shear, since he's here.
Okay.
If he has a moment, because I was a little bit unclear from having read his email what his bottom line was on this. And Mr. Shear, if you could just preliminarily describe this board assets organization that you are associated with.
Is the green light on?
Green light's on, yes, sir. Board Assets is my organization. I'm a many-year involved in the world of corporate directors. I was CEO and chair here in New England of the National Association of Corporate Directors. I serve around the country training and educating directors, and also serve as an expert witness in a variety of court cases relative to corporate governance. And I looked at the, do you have a specific question, or did you want me just to, revise my comments that I made?
Well, I don't want you to repeat your comments.
Yeah.
They're part of the public record.
I would say one
I'm
thing.
wondering where you were coming down on this, in terms of, in practical terms, it seems to me, your conclusion is, it seems to me that regulators are better served focusing on the performance of directors, not merely their backgrounds. And what does that mean in practical terms?
Well, I tried to point out in my comments that the process of recruiting and electing directors to public company boards is a rather rigorous one, and it's hard for me to believe that the four criteria that we talked about before, that you've been talking about, would not be present in the background checks that were done prior to a recommendation for election to the board. So I don't think those in particular would need to be additionally applied by this authority. And it would seem to me that you could rely on the work that's been done to get a, by the way, independent outside director. I want to be clear that language, independent, defines somebody that has no relationship with the company except their status as a director. Because the word outside director might be defined to be somebody, for example, in the family but doesn't serve in a management capacity in the company. So to be clear about that. But that being the case, it seems to me to be a waste of time to spend. I understand the form is a 67-page form and a fairly rigorous process, and you all could depend on these other checks that the public company would make on a director before they would elect them to their board or her. And to the extent that you had other jurisdictions that were going through the same process, that would just make me feel even better about the need not to do rather extensive work for your process of approving an independent outside director. I would say, and the reason I said about performance, it's conceivable that the actual corporation, the actual director serves on another corporation which engages in activity that you wouldn't find helpful in terms of the role that you have here, that they would have in Massachusetts. And that's what I meant when I said you might look at their performance as a director. I wasn't talking about their, attendance at meetings or something, but being involved in another corporation which was involved in a fraud or outside money coming in or some other issue.
I see. So that, just sort of summarizing that, if I understand it right, you're saying that the practice is amongst public companies now that in order for an independent director to be appointed as a director, is that he or she goes through a very significant vetting process necessarily, and that we could attach significance to that fact.
That's correct.
And then secondly, I hear you saying that if a director had been approved by another jurisdiction for his or her place on a gaming public company's board, then it would be appropriate to attach significance to that.
Correct.
And then finally, that even if somebody, by definition, had been appointed, even if somebody, by definition, had been approved or permitted to be approved to be qualified in another by another gaming jurisdiction, that you would advise that in our investigation that we focus on whether or not that director had served on other public companies, and then make an inquiry as to the record, in effect, the performance of those public companies, to see whether or not there were any issues of a lack of oversight by the board of directors at that public company while he or she had served on.
Yeah, I was thinking more in their current roles. So in other words, not what they had done in the past, because that would have been caught before they were elected to the board of this particular gaming company.
Okay.
But rather, in the last fiscal year, whatever it was, whether they were one of the other companies that served on the board had a particular issue.
Okay.
And that would be a fairly easy thing to do, I think, not requiring a lot of effort.
Well, that's helpful. Thank you.
Anybody else? Thank you, Mr. Shear.
Thank you.
Thank you.
Okay, so we have a process in place for pursuing this. Director Wells, you're back.
The next item on the agenda is qualifier suitability determination. You've already received the background investigation report for the MGM qualifier Yakima Brookins. So as on the agenda this morning are the results of the suitability investigation and a vote by the commission on her suitability. Ms. Brookins has been working for MGM since 2006 as a result of a promotion to Executive Director Internal Audit at MGM Resorts Regional Operations in Maryland in January of 2016. She was determined to be an individual qualifier for the Massachusetts Category 1 license Blue Tarp Redevelopment LLC. She submitted all the required forms and supplemental document requests to the licensing division and the IEB, and investigators conducted the rigorous background check. I've gone over those areas before, including employment history, criminal record, education, etc. She was interviewed in person by the state police and financial investigators as part of the investigation protocol, and they also conducted a financial responsibility evaluation, and that resulted in a conclusion of a positive determination for suitability. Ms. Brookins attended Alma College in Alma, Michigan, and Oakland Community College in Royal Oak, Michigan. She then attended Walsh College of Accountancy and Business Administration, where she was awarded a Bachelor of Business Administration in Finance in 1987, and later a Master of Business Administration in 2001. As I stated, she's currently an Executive Director, Internal Audit of MGM Resorts at Regional Operations. Prior to that position, at Beau Rivage Casino, she was the Director of Internal Audit. At the Gold Strike Casino, she was the Director of Internal Audit. She was, prior to that, Senior Manager and Director of Internal Audit at MGM Grand Detroit. And then prior to that, she had other jobs not in the gaming industry, including being a business analyst, an officer of fraud investigative services at a bank, a business analyst at a company. In addition, she also did data processing and office services. Ms. Brookins is registered, licensed, or has been found suitable in the 3 following gaming jurisdictions: Michigan by the Michigan Gaming Control Board, the Mississippi Gaming Commission, and the Maryland Lottery and Gaming Commission. Investigators confirmed that she has been found to be in good standing in all of those listed jurisdictions. Overall, no significant issues uncovered related to her application for licensure, and she demonstrated by clear and convincing evidence she was suitable for licensure in Massachusetts. Therefore, the IEB is recommending Commission find her suitable as a qualifier for MGM Resorts.
Thank you very much. Questions, comments?
Mr. Chair, I agree with the conclusions of IEB and move that we find Ms. Brookins suitable for this position.
Thank you.
Second. Further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously. Thank you very much. Next up,
Now for the fun stuff.
yeah.
So,
And what
I-
do you think about gaming service employees? No, I'm kidding.
Do not say a word.
a lot, every day.
Yeah.
I have a few items on the agenda for you today. First up is
Yeah,
the...
can you introduce yourself, Paul?
Oh, I'm sorry. Paul Conley, Director of Licensing. The first up is the licensing quarterly report. The reason behind this quarterly report is, as you remember, when we made adjustments to 134, some employees and vendors that previously went in front of the commission are now come out of the Bureau, the determination. So we thought it would be important, since you were seeing fewer of these in real time in front of you, to put together a quarterly report to discuss activity and open it up for any questions you might have. So what you see in front of you in the two slides is purely an activity count. The first slide regards the number of vendors that have been licensed or registered in the first quarter of this year. Of note, that 64, the non-gaming vendors, back in, again, at the end of January, changes to 134 went into effect that required a statement of business relationship from an NGV before we would process them, as well as opened up a de minimis exemption for anyone who was expected to receive under $10,000 in 1 year from a casino. That has actually significantly impacted the number of non-gaming vendors that have come through our shop. I fully expect, even though there'll probably be increased activity with the two Class 1 licensees in the next quarter, that number will drop from this quarter because the statement of business relationship has had a tremendous impact in terms of streamlining the number of applications we see. In short, it's had its intended effect.
Because the statement of business intent puts in the amount of money?
The statement of
No,
business
they have a
relationship basically indicates that it's reasonably likely or assured that a company will do business with the licensee. The previous model is that anyone who wanted to seek registration, we would process them. And what it ended up with is a relatively low utilization rate if you look at it in terms of the number of companies that we have registered versus those that are actually doing business, which also meant it was a significant resource issue on our side to process both the applications and do the investigation on each one. So that was the rationale we had to bring it forward, and it really has had an impact. We're seeing the intent. I also want to point out, not only that, there's been a lot of process changes with that, and I want to thank and commend the licensees for helping us out through that process, through that change. It really, it started out as a little bit different, and we're really in a good place right now.
Great.
Paul, in this first slide, you get a sense as to whether there is any of these that are already pertaining to MGM, or is this mostly PPC?
This is across all three licensees.
Including.
Yep.
Well, of course.
Yeah. As a matter of fact, if you look at the secondaries, 3 of the 5 are directly related to MGM. A number of the non-gaming vendors, I don't know the number offhand, nor do I have it in front of me, but a number of those relate to Wynn. The one primary, obviously, relates to Plainridge Park. However, just as a note, where we stand right now, we're both in the renewal phase for existing primary vendors. So we're starting to notify those primary vendors, that they have to get their applications in for renewal because, again, it's a 3-year cycle, as well as identifying, in collaboration with the licensees, the primary vendors that they intend to utilize upon opening. So we're gathering that list, working diligently, because we know, if you think of what can kind of choke the system, it's those primaries, because they're big, they're complex, and they take a lot of time, not only to get the information, but to do the investigation. So we're working very hard right now to identify them and get them into the pipeline.
Excellent.
The second slide pertains to employees that we've licensed or registered in the first quarter. Again, the vast majority of those would be Plainridge Park, although there are a number that are MGM and Wynn, as their MGM in particular is starting to ramp up some of their executive staff, as well as some of their support staff. So some of those service employees, really where you'd see it is in the keys in the service where MGM is having an impact. And
Where are the service employees going at this
so-
stage of the game?
So again, service employees who might be working in MGM's offices in Springfield right now, but they're not, related to gaming, nor are they, the higher executives. It's really, you have that kind of top of the pyramid as well as support staff right now where they stand in their function. Obviously, that's why you don't really see any gaming employees from them yet, because those are a lot of the folks who tend to be that core gaming function type individual. So next up is
Before we move on, I think it's great, and as we talked about, we appreciate these reports and look forward to the next ones. Maybe on a future one, I'd be interested in starting to get some metrics as to an average time it takes you to do certain level of, any one of the categories. To try, and I know you've done a lot of work on these, and LMS is going to help you tremendously in terms of getting an accurate average of time, and there's always exceptions. But to the extent that we could get a sense as to how long some of these licensing and investigations take, turnaround times and so on, I think on an average basis, that could be really helpful.
I think an average by category would be,
Yep.
Pretty easily achievable.
I would add to that, obviously, because of the changes in the regs, you're also opening up the opportunity to put somebody on administrative closure. It'd be interesting to kind of keep tracking your success or, what those numbers start
Right.
to appear like.
Yeah, absolutely, and that's the item after the forms. Thank you for setting that up. Just as a point of note, Karen had mentioned earlier, and I didn't have the number in front of me, the number of service employees applications that we've actually seen throughout time, the number 739 as of about last week. So just, I had that, I couldn't file through my papers quick enough to.
With one denial.
On one denial on the automatic disqualifier.
One automatic disqualifier.
Correct. Correct. So next up is the forms. Last meeting, we were in front of you to introduce this, and today we're hoping if it is possible to have a vote to approve the new forms. Again, with the 134 reg change that was implemented in January, the previous iteration was that every element in every application was specifically outlined in the regs. That had been very helpful, but it also had its points that were difficult. It was difficult to change and be flexible and nimble. You could always point to the reg to say, we asked for it because and it's there. But what we did instead was to change the reg such that now divisional licensing can make changes to the form, present them to the commission for approval. Obviously, they're not in effect until you approve them. And then some non-material changes, for example, maybe some instructional language or anything that didn't have a significant impact, we could make in consultation with the executive director. To back it up a step again, these forms are really tools to accomplish two things. One is to identify someone so that we're starting that relationship as a registrant or a licensee with the commission. So we clearly identify someone, create a file on them, so to speak. In the electronic world, we create a master record that's going to track all activity about that person in terms of licensure and registration throughout their life cycle with us. And the second set of information is information to support the background investigation to support the statutory requirements. So the first thing we did when we wanted to review the forms was we sat down, IEB and licensing, and did the analysis of, are we asking the questions we need to ask, right? Are we getting all the information we need? Is there a more efficient way? And also, are there any questions that are really kind of low-value questions, meaning they're answered very seldom, and when they are, we're really not deriving much value from them, so let's be efficient. The second pass on the analysis was to try and kind of rationalize these. So each form asked similar questions, but often in a different sequence. So we went through and just put them in the same order, but also worked to make sure that the order of the questions made sense as someone was going through. I constantly try, and my team, Bill Curtis is a master at this. We sit down and try and play the role of an applicant. We really do, and say, what's it like to fill this out? What's hard? What do you have to do homework on? Constantly trying to think of that piece. What do you have to go and get a secondary document? Because again, all of these questions feed into the electronic world, where if we want you to sit down and do an application, we want it as seamless as possible. We don't want you to have to go to the filing cabinet at home or the safe to pull up information. We want you to have to do that as seldom as possible, or more importantly, as efficiently as possible. So we went through and did that analysis. And finally, we went through and tried to simplify wherever possible. Place you see that probably most prominently as compared to the previous forms is in the instructions. We cut them by about half. Went through and really made sure that what we're putting in the instructional information is the most important, the most relevant, the most understandable. And also in some of the notes, and we had a good discussion with Commissioner McDonald about this yesterday, making sure that one, we're noting where folks where they're getting fingerprinted, but how that plays into a background investigation, because we want people to understand what they're getting into when they start this process. And secondly, and very importantly, is that these forms are subject in part to public records requests. People need to know that when they're providing us information. As we all know, everything we do is open to public scrutiny and public records requests. So we went through and tried to simplify. I'll have to admit, I had grander designs on simplifying than I was able to achieve. And there was a really good reason for that, which is why it's always good to go back and do these exercises. Every question, we're looking for very specific information, and it's really hard to ask for specific information with a general question. So I wasn't as successful at kind of, making the question shorter, but we certainly did wherever we could. We did do that. Of note, as a kind of a theme throughout the applications, we added wherever possible the ability for someone to indicate that this question doesn't apply to me. That, from a process perspective, had been a bit of an Achilles heel, where if someone didn't answer a question because they said, obviously I left it blank because it doesn't apply to me, unfortunately in our world, the absence of an answer does not indicate an answer. So we'd have to send it back and say, just indicate, NA or whatever. So we're trying to get rid of that by making it pretty clear. Of note too, on the based on discussion and feedback on the service employee application, we've removed the DOR request. So previously we had asked for that. That after discussion is no longer part of the application.
For the SERs.
For the SERs only, correct. So
Questions or?
I'm sorry,
Yeah.
Chairman. I just one note. Again, these are the paper forms. A subset of these you'll see in LMS. So we'll be back to talk about that. But in substance, that you'll see kind of an extract of these same questions. But what we don't ask for electronically, and we're putting into that PDF as part of the hybrid version, you'll see come poured over into the LMS world.
Great. Comments or questions?
I like these forms very much. I went back and compared them to the initial forms, and just to get a reminder of how much we've evolved, really, in terms of much of it prompted by the efforts of the LMS, by the way, which can incorporate attachments and so on and so forth. But it's a great reminder of the efforts that you've done all these few months, really, in terms of trying to streamline, simplify, and really obtain the information that you most need to query and license and investigate and so on and so forth. So I think it's a it's great.
Thank you. And again, this was really the definition of a team effort. The whole licensing team was involved. Bill Curtis was, really ran point on a lot of this. IEB, we did, to your point, we really did go back and try and question everything. So it took a long time, but it was well worth the effort.
And now coupled with our regulations that have also been simplified significantly, and these are incorporated by reference, I think the job is overall really in a direction that we really wanted and is beneficial to the applicants.
Yeah, I would concur. And I do appreciate the exercise of having your staff sit down and fill it out as an applicant would, and what are the challenges, what are the pieces that aren't that easy to maneuver. So that's really worthwhile, and it does take a lot of time. So congrats to your team. These are well done.
Thank you.
I told you when we talked that I have concerns about the GSE form, but that's subsumed in the other conversation.
Correct.
As long as we're doing things the way we are, then this form is appropriate. But Enrique in particular made some comments, I guess I did too, that I thought you had accepted. I didn't keep a list of them thinking you were, but I see two that I thought had changed that haven't. One is the adding Hispanic Latino to the category.
Yeah.
And the other one was, you were going to say something about self-answered, the descriptive information, so you don't get into came up in the gender issue, and you were going to put something about self-selection or something like that.
Right. The bad news is this is not the last time you'll see me. We're revisiting that whole section about race and gender, and we're trying to do it smart. So you'll see us, I'm sure, shortly coming back with some recommendations on how to change that.
Okay, so this does not reflect all of the comments that we made.
Well, I would add, though, I note from the regulations that for small changes, like administrative changes like that, the director of licensing can go to the executive director for approval. So that kind of thing, if the commission thinks that's a good idea, we can just do it administratively. We wouldn't necessarily, for smaller things, have to go before the commission.
Yeah. Well, it's not that, the only issue is that there were some things I thought that Enrique and I agreed should happen that haven't happened, but assuming they would, I didn't keep a list. So I don't know whether there's anything else that didn't happen here that.
So, and on those, we did, in talking with different commissioners, that kind of erupted into we need to look at the whole race and gender. Just to be honest, we want I want some very strong guidance in terms of what that should look like. As I've said, we have looked across a number of different state agencies, and if you look across a broad section, you see it different ways, and there's not, unfortunately, one standard, which would be great. And when we do it, my only caveat is we just want to make sure we do it thoughtfully and carefully, which I know we would, but because I'm always thinking how this impacts LMS, that is a significant kind of data model change where suddenly now that's not one of those things where we're just changing the form at a whim, which is part of our design by intention, but this would be something that's part of the master record on a person, demographic information that would be. So at a certain point, too, we'll have a change where, the population up to that point was recorded this way. It'll change. That's no big deal. That happens all the time and should never be a barrier to change. But we just want to make sure that when we do it, it's we're doing it and coding it properly.
And we're doing it once.
And we're doing it once until such time as it makes sense to do it again.
Right.
So different state agencies record this data differently?
They do. And there's and we have in the past, a lot of times leaned on and relied on some of the law enforcement databases for a couple of reasons. One, because they've been doing it for a very long time. Number two, it meshes very clearly with doing background checks, and if you're running criminal checks, you're seeing things line up one-to-one. And also, it was an area that a number of those kinds of databases have been worked on recently and have been trying to update. But to be honest, it's an area well outside my expertise. So we're trying to figure out the best way to drop the categories, and also, as you said, even with gender, how do we approach it? And that's a quickly evolving topic.
The main one, the most obvious one that Commissioner Zuniga and I talked about is that to say Hispanic, there is no place on here for people of Portuguese descent from Central and South America that would not consider themselves Hispanic, and we suggested that we call it Latino Hispanic, which would include Brazilians and so forth. But, okay, so.
And to that end, I've seen more confusing forms in other
That's
state
true.
agencies where that, much more,
Yeah.
where Hispanic is a second question, it's not a race, and then
Non-Hispanic white.
non-Hispanic white, and that, produces, even for people like me or my family, confusing, and a confusing environment. But
Okay,
You know-
all right, so was there anything else that we talked about that hasn't been done here, that's still an open question? You made us some other ones, too.
I think they update, yes.
Karen, is your mic on?
Oh, yeah, the Hispanic Latino, and there was one other issue that Commissioner Zuniga and I had talked about, but I think we're all set for now.
Okay.
It is something you have to be careful with. I mean, in New Jersey, it's optional now, the race question, because they've had lawsuits. And so I like the fact that you're being thorough and trying to think through the best way to do it.
Right, and off topic, but just as we, as we think about this area in particular, wherever we go with it, I'd always advocate too that we're collecting this information in LMS. It has obviously no impact on a licensing decision, but is used more for kind of reporting. But to that point, it's not. I would suggest we don't use it for reporting, but as a way to verify reporting from the licensees as they report their statistics, we can say it's in alignment for exactly those reasons. People may go through two different applications and answer differently two different times, or not answer a one time or another. And so it's a difficult area for reporting sometimes, because you can have, just where it doesn't match up for very, very rational, understandable reasons. So just, again, one of those other areas that these seem like they're simple questions, and then when you get smart people in the room, you realize they're not.
And you get nitpickers in the
No.
room, you realize they're not.
Paul, one quick question. Places on the application, albeit in paper form, you say you need more space, attach a separate sheet of paper. How will that work when LMS is up and operating?
So in the LMS world, it'll work a couple different ways. We've actually, in the draft of the kind of PDF in LMS, it has a second page or an extra page already in it that you can upload. But we can also, as long as you can scan a document, you can upload it and give it an attachment name. So fortunately, we've accounted for that because we know it's going to happen. What we hope to is that we're seeing it less and less, to be honest, because we've kind of right-sized based on experience the space. So it'll be an infrequent event, but you can always in LMS upload additional documents.
Okay.
And worst case scenario, there's always the ability to, if someone were unable to achieve it for whatever reason in LMS, they could send it to us and we could add it to their file.
Okay.
So.
Thank you.
Okay, anything else? So what do we need to do here? Is this
a vote?
Are we a vote here?
This
is a
we're-
vote.
All right.
Mr. Chair, I move that the commission approve the updated license and registration forms as provided in the packet.
Second.
With somehow subject to an
Typographical.
pending review of the demographic
Right.
section. Okay. Any further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
This applies to all three on the packet, right?
There's
All
four.
Four.
Service
That's right.
employee, gaming employee, key gaming standard, and the non-gaming
And
vendor.
the non-gaming event.
Right.
Thank you.
Next on the agenda, this is the first time you've seen this, so this is a request to change an existing regulation regarding administrative closure that Commissioner Stebbins had mentioned a moment ago. This is a relatively new element of our regs. We added it when we updated 134 because previously we hadn't had the ability to close out an application. Essentially, take an application off our books, so to speak. I say that, we'll always keep it, we'll always have it, so nothing gets lost, but enable to kind of take it off of our active roles of what we're, have to be accounting for. Administrative closure, again, is for someone who's non-responsive in the process. So if Karen applies and in the licensing process before she has been, submitted a completed application, if there's something outstanding and we request it and she does not comply, we could administratively close her application. Additionally, if she does have status already as a registrant, or has a temporary license, and an investigator, as they're going through, says, hey, you know what, there's something else that we'd need or I'd like to see. If she's non-responsive at that point, we could administratively close her application. So we currently have that ability based on the existing reg, and what we're asking is that we make a few changes, and the changes are the following. First of all, we have two different time frames existing for vendors and employees. I'll be the first to admit, I think we were a little bit trying to be too clever when we wrote the first draft. We gave 30 days to a vendor, 14 days to employee, thinking that if someone's part of an employment process, it should be top of mind. 2 weeks is plenty of time to get it back, whereas sometimes businesses, they have a lot going on. Maybe the business they're trying to chase is a few months down the line, and so we give them more time. It sounds great, but what we're asking to do now is to basically harmonize those to 21 days each. The second major change is that when an application was administratively closed, and currently, not was, but currently under the existing reg, that there's a 30-day period, kind of a penalty period, right? So that it was some teeth to the reg to enforce compliance. If we close you out, you're basically on ice for 30 days and you can't reapply. That was based on our experience from a while back that, frankly, we don't think is relevant anymore. We think that we can still gain the same kind of compliance by removing that 30-day to allow someone, once we close you, you can come right back. Additionally, and very importantly, in conversations with the licensees, there was concern that kind of putting someone on hold for 30 days, especially on the employment side, could be disastrous and create too much uncertainty for them. So we're very sensitive to that, and it really made a lot of sense. So what we're asking for now is that once closed, someone can immediately reapply, right? But in order to do so, they have to submit a complete new application. That sounds more onerous than it really will be, particularly in the LMS world, because what that would mean is someone would have to go back in, they basically can resurrect their old file, add what's new, but then importantly and technologically, it's submitted as a new instance. And we would know that they had originally been administratively closed, we'd make sure that they provided to us what it was we were looking for in order to completely process them. And so that's really the thrust of the changes that we're looking for. And we think it'll make the tool a much more effective tool without some of the collateral damage that it may have caused with that 30-day cooling off period. And importantly too, this will make it a lot easier to develop the flow in LMS and account for it.
And I think what's important to note here too is that you don't only ask once for the information. You have a
Correct.
tickler system in place where an email is generated and or a call, just, hey, we're still waiting on this. So the person is not just notified once and then 21 days later they're closed out. They
Correct.
will be notified in an interim way.
Right. That the clock is ticking.
Does the LMS do that automatically?
So currently it doesn't, but that's what we're building that in. And we already have kind of the guts for it, so to speak, in terms of once we have your email address, we can notify you about several kinds of events. We've been talking with the licensees about some things that might make sense for them. They want to kind of, in the same way, it follows really hand in glove with the administrative closure as kind of an inactivity flag. If someone hasn't touched their account, if they're of a status prior to registration or licensure and they haven't touched their account in so and so many days, that they get an automated email. Same thing, all to make sure that people are moving, advocating for themselves, moving their own app along. So we certainly can do that and are talking about that now.
I think that's essential, is having the relationship with our licensees so that they're aware of it. It's just not a communication between us and the employee, but we don't want our licensees to be surprised when
Right.
Karen can't show up for work because she's been administratively closed, and all of a sudden they're
Right.
fretting about where she is.
Right, we both, everyone has an interest in moving those employees through, and theirs is obviously, different than ours, because they're looking to get someone to working on the floor and fill a space, and so we're very mindful of that.
So are these here for, to begin the formal promulgation process? Remind me
This
what.
is here for your initial review. If you would like, we can put them out for informal comments, but you need not vote on them today.
Okay.
But do we need to put them out for informal before we go to the formal process?
No, you don't have to.
Oh, you don't have
We've
to.
done that
We-
in the past,
we
but if you
frequently
feel
do.
comfortable with it,
Yeah, I mean,
we
I
can
just
just.
don't see why we wouldn't just go ahead and start.
Although does it need a vote for that?
Yeah,
It's
I
not
mean,
listed as
you'd
vote
need a
on the
vote to take
agenda.
them through the formal process.
Yeah.
So we're not scheduled to have you vote on them
Oh,
today
all
because you
right,
hadn't
okay.
seen these before. But we can bring them back at the next meeting and then do
Yeah.
the vote and
Okay,
just take
fine.
them forward.
And obviously, if someone was watching and wanted to comment,
Right.
we'd take that.
Okay,
Thank you.
Thank you.
thank you.
Thanks.
Thank you.
Item 6, Legal Division.
We have Mr. Grossman and Mr. Glennon here to talk to you about the changes to 205 CMR 143.
Groovy.
The draft before you, you've seen once before. It was here 2 weeks ago. We circulated this for informal public comment. We, in fact, did receive one comment from Scientific Games, which we're in the process of reviewing. We'll be in communication with them. We are here before you today, though, to seek your approval to begin the formal promulgation process for this set of draft regulations. There are certainly a number of provisions in here that we're interested in receiving comment on, notably the provision that provides that the malfunction voids all pays. We've had some spirited internal discussion about what the process should be, what the language should be in that regard, so we'll look forward to discussing that in the future. I'd also just quickly draw your attention to the very end of the document where there's some green language. That is new based upon some internal discussions we've had. It pertains to certain reports that are required
Where's
from...
the green
We don't
language?
have green.
Yours does not have green language, okay. Oh, did it make it into red?
We all have red.
Everything's in red.
Okay.
Just give us a section and we'll.
It's 139.04.
Yep.
Yep.
Do you have, how many reports?
Mm-hmm.
Well, okay, there's an updated one that has 16 and 17 on it. I guess you don't have that.
We don't have that.
No.
Okay. We can do that separately. That's not, it has to do with reports. So, a preview of coming attractions. We'll come back before you with some reporting language. In any event, at this point, then we would just seek your approval to begin the promulgation process. We'll have these filed and file the appropriate notices, set up a public hearing.
If you had already thought of, oh, well, the formal promulgation process would still allow us to come back with 16 and 17.
It definitely would,
it-
yeah.
Right?
Yeah.
Or any other changes
I-
based on comments.
There may be other changes as well.
Scientific
Right.
Games comments.
Yep.
Sure, yes. We'll speak to GLI about these and all of that in between now and the time you re-review this.
Any questions, comments? Do I have a motion?
So moved. Begin the formal,
Oh, there it is, there. There's the
16 and 17?
oh, there it is.
language.
All right, so we have a motion to begin the formal approval promulgation process,
205 CMR 143.
.01.
Oh, one.
So it's 143.01, it's 138.56, and 139.04. The green language that I was referencing actually just popped up on the screen there. There it is. It I can just represent to you, having obviously not seen this before, that it just has to do with a number of reports of certain data that comes out of the slot machines relative to gaming revenue and the like. Of course, at this point, it would just go out for public comment. I don't think there's tremendous risk in circulating it, including it as part of the draft at this point.
So just to add to Todd's point, these reports are to incorporate the daily financial information provided by the casino. So when you have 4 different licensees, there are a number of reports where one casino licensee provides it in one format, and another casino licensee provides it in a completely different format. So we're trying to standardize those reports so that our financial team doesn't have to translate that information and create data entry error.
Makes sense.
So there's a motion on the table that was a mishmash of 3 or 4 speakers. Do I have a second?
Second.
Second.
Do we have further discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously.
Thank you.
Thank you very much.
Thank you.
Thank you.
Mr. Vanderlinden is nowhere to be found. We'll take a quick break. Reconvening public meeting number 215, and the next item on the business is Director Vanderlinden.
Well, good afternoon.
Good afternoon.
Good afternoon.
So this is our final agenda item for the day, I believe. I wanted to kind of give you a general update on what's happening with the research agenda that covers a couple things. One is kind of reviewing with you what are the reports and studies that are going to be coming out over the next several months. And then also just a very brief update on where things stand with the special population study that we have out right now, what the status of the applications are. So first, I wanted to just give you an update here of the studies that we have in the field. I'll talk to you about what's happening with SIGMA and MAGIC, Social and Economic Impacts of Gaming in Massachusetts, and MAGIC, the Massachusetts Gaming Impact Cohort. Both of these studies are being led by the University of Massachusetts Amherst. MAGIC is a study that the Commission launched back in 2015. A cohort is basically our ability to follow a group of people over the course of time. What we get from following a cohort of individuals is it tells us a lot about what is the incidence of problem gambling in Massachusetts. That is different than prevalence. Incidence is going to tell us more about what are the new cases that are coming into the general population in Massachusetts versus prevalence, which is really just a snapshot at a given point in time. That is important for us, very important to inform a public health approach to addressing problem gambling, because it will tell us a lot about what is leading up to an individual developing a gambling disorder or gambling problem. It'll tell us a lot about what is the difference between somebody who takes a path towards recovery versus stays on the course or stays continues to have a gambling problem. It'll tell us a lot about recovery and what supports somebody in recovery. This is an unprecedented study and a huge undertaking by ourselves, the Gaming Commission, as well as the University of Massachusetts, led by Drs. Volberg and Williams. I'm excited to report that we will have a report on Wave 2 of that study. And Wave 2 will be a comparison, basically, of what happened from Wave 1. And so we'll begin to be able to put some details to how is that cohort doing and what are some of the characteristics of the cohort. Wave 1, by the way, was pulled in the general population survey, that very large survey of 10,000 individuals, adult Massachusetts residents. So Wave 2 is a deeper analysis of those individuals, but it's comparing it to the general population baseline information that we have on them. This report will be first released during the UMass annual meeting. That annual meeting is on June 9th. that is certainly something that our research team is working on pulling together that agenda right now, but this will be front and center, I'm sure, at that time. In and around that time, we'll also be sure to bring Rachel and possibly Rob to a commission meeting so they can give you an update on that and give a full report of it as well.
Mark, what is this UMass annual meeting?
Well, thanks for asking. I actually am pulling together a save the date right now. So for as long as we've been working with UMass, 4 years now, they have hosted an annual meeting. And it's basically a way to do a deeper dive into describing what are the research activities, what are and methods that they're undertaking to a host of.
Meeting of our research team.
Correct.
At the University of Massachusetts. It's not a larger.
No.
University of Massachusetts wide.
Right.
Congregation.
No, but our search team is more than just UMass. I mean, the second PI is from Leicester, Lethbridge University in Cambridge, I mean, in Canada, and we have key investigators from University of Las Vegas, Nevada,
Right.
and et cetera.
So they host an annual meeting for the research team, and coinciding with that is an annual meeting where they invite a whole host of stakeholders to come in and learn more about the research projects. That will be on June 9th, and certainly as a training, we'll make sure that commissioners are invited. Okay. Next, moving to the SIGMA study, the social and economic impacts of gaming in Massachusetts. For quite some time, for the past couple of years, they've been working on what we call the CHIA report, and that's data pulled from the Center for Health Information and Analysis. I like to call this the big data report because the database that this is being pulled from is the Massachusetts All Payer Claims Database, which really covers all medical, pharmacy, and dental claims and information in Massachusetts. So pulling from an enormous amount of data and being able to draw out individuals that have been diagnosed as having a gambling problem or gambling disorder, and being able to say a lot more about what other types of medical services that they receive, what is the cost of those medical services, so you can begin putting, to some degree, a dollar amount on what is the cost of treating individuals with problem gambling in Massachusetts. Again, this is, I believe, a cutting-edge study that looks at the true costs of problem gambling from a slightly different angle than what has been done before. This also will be presented during the annual meeting on June 9th. The report is largely done. It's been submitted to a peer-reviewed journal. It's going through that process right now through the peer review process, and they're making a determination on whether or not it would be selected for publication. I expect that we will have this report in our hands probably very, very soon. As opposed to going through our own peer review process, this is going through the peer review processes at these journals. And so it's a slightly different path than what we're doing right now. Moving on to the second page, the patron survey report. So the patron survey report is actually conducted by it's a school within UMass. It's the School of Hospitality and, I'm sorry, I'm drawing a blank on the name of the exact school, but still it falls within the larger SIGMA study. And the idea for this is to get clarification on patron origin. Are we recouping dollars from individuals that are coming, or are we gaining dollars from individuals that are visiting from Rhode Island or Connecticut or New Hampshire, Vermont, who is coming to Massachusetts? Are we repatriating the dollars that before this casino existed were leaving the state, and getting some clearer idea of how they're spending their dollars during their visit to the casino and the surrounding area? We also included a number of questions about game sense, knowledge about game sense, attitudes about game sense, and that will be added to the game sense evaluation being done by the Cambridge Health Alliance. This
And by definition, would this be limited to the patrons at Plainridge?
Correct. So the method for this was they did 2 patron intercept surveys, one in July of 2015 and a second in February of 2016. They selected at random patrons that were leaving the casino to interview them. They also did a license plate survey within the parking lot.
Mark, on this topic and a couple others further down in your report, I just want to be clear, you talk about a final report is expected on a certain date. Does the final report mean no further patron surveys, or there's a patron survey final report for X period, but there will still be patron survey efforts kind of going on past that point?
Right. It's the latter. It's
Okay.
that this is the final report for this time period. For example, in the patron survey report, we have in the research plan that we will replicate that starting, I believe, in February of 2018. We'll be back out in the field to do that. We'll also do the same once MGM and Wynn open up.
Okay, great. Thank you.
The patron survey report is expected in June 2017, and again, this will be highlighted in a deeper description of it during the SIGMA or UMass annual meeting. The next report is the updated general population baseline population survey report. We've discussed this, I believe, back in December when we described that we are reweighting that survey, which has an impact in a number of different ways, most noticeably in how we describe the prevalence of at-risk and problem gambling in Massachusetts. We believe that the new weighting methods provide a clear and more accurate description of gambling, problem gambling in Massachusetts. That it's a small shift overall, but it's a significant effort that required our research team to literally review the entire document, rerun all of the tables that are in there. The final report for this is expected in July. The next one is the Plainridge Park Casino New Employee Survey Report, and this actually will be presented to you our next meeting on May 10th. I won't say too much more about it other than it's really kind of a review of new employees hired for the first 2 years of operation at Plainridge Park Casino, trying to understand where they're coming from, what their motivations for seeking employment specifically at Plainridge Park Casino are, what their employment status was prior to working at Plainridge Park Casino. I think it does a great job of kind of painting a picture of the workforce that we have and what their impacts are on the local economy.
Mark, did we do one of these before, or did SIGMA do one of these before, or is this the first time?
This is the first time that I recall. Next is the Shiny interactive web applications, and this we've discussed several times previously, and it really does speak to, we have a lot of research that's being generated through our research teams, and and this is going to be an ongoing issue, and I think to try to figure out how to communicate this data, these findings, to the appropriate stakeholders. So we have research that's actually applied as opposed to sitting on a shelf. Shiny is one such way in which we hope this data will be used and disseminated in ways that will maximize the benefits of expanded gaming in Massachusetts and mitigate the potential harms. We've done a lot of work on this. I think we've seen several iterations of it. And in fact, the status of it right now is that we're continuing to explore new methods and approaches of sharing the data. so that Shiny can be a better app, a better and more usable app for key stakeholders, residents in Massachusetts. The next one is the Plain Ridge Park Casino 12-month operation report. This is kind of a broad general overview pulling together a lot of different measures, but really overall what it's intended to do is give a picture of operator spending, patron spending, government and fiscal impacts. The report will be released in June and highlighted during the annual meeting. If you don't get the sense already, the annual meeting is going to be
It's a big deal.
jam-packed. And,
I guess we're going
and
to
I really
Amherst.
hope that you're able to attend. Moving down the line, we have the impact of gambling on public safety in Massachusetts cities and towns, better known as our crime study, being led by Christopher Bruce, not by Dr. Bolberg or Dr. Williams. We presented the 6-month and 1-year report. The 12-month report, I believe, was back in December. Christopher is preparing an 18-month report, and it's not a report as we presented the 12-month report, but really it's an update and him monitoring all the different public safety measures that he presented back in December. The intention of this is more so that we can kind of keep our finger on the pulse of what's happening at the casino and in the host and surrounding communities. If there are issues that are arising, that we don't sit on them and wait for a 2-year report, but that we can rapidly respond to any issues that would be coming up. So.
And Mark, do I understand that Foxborough is now on board?
Yes, that is fantastic news. We're excited to bring Foxborough into this part of the study. It was a noticeable gap. It was clear when it was presented, but also just as we apply these methods and it was noticeable that Foxborough wasn't there.
Right.
We're really pleased to be working with their police department to include them and get a clearer picture of what's happening.
I suspect he won't have time to include that information until the next report.
I believe so. I reached out to Christopher just to kind of make sure that we're on track for April, which is we really just have a couple days. But
Yeah.
his idea was to be able to roll Foxborough
Part of it is he
into
couldn't
that.
extract until they had the money to buy that piece, that modem.
Oh, okay. All right.
So I suspect by the, and that was approved, so I think
Yes.
by the time he
Yeah.
does another 6-month report,
Mhm.
there will be an issue. You touched on this, Mark, which is, it's good to do it every 6 months because it's somewhat real-time information, but actually, he's extracting monthly, and he can, if there is something, he can deal with it with that police department immediately, which is a real benefit to these smaller agencies that do not have a crime analyst. So that's a benefit for the communities that choose to be involved.
That's great.
Yeah, it is. So then, moving on to the evaluation of key responsible gaming initiatives. There are 3 studies, 3 evaluation studies that are all being carried out by Harvard Medical School, Cambridge Health Alliance Division on Addiction. Voluntary self-exclusion, the Game Sense program evaluation, and Play My Way. So the voluntary self-exclusion program, this is a longitudinal study of VSE enrollees and provide information both on how to improve the program, but also it will give us a clearer picture on what of individuals that enroll in the program. Wouldn't it be great to be able to have that information and begin to develop predictors of persons that enroll so that we can begin developing either targeted intervention or prevention tools and messages. This specific study has struggled with getting enrollment. We are slowly but surely enrolling enough people where we can begin to kind of develop a clear enough picture, or so my hope is that we will continue the enrollment process through November. At that point, we will have that sort of critical mass that we'll be able to draw some conclusions. Once the enrollment ends in November, we will continue to do the follow-up, that longitudinal follow-up with those participants, so that by June of 2018 that we will have a complete report. I am working with the Division on Addiction to develop an interim report, kind of it's more of a status update than anything else, that will be delivered to us in June. One additional, I think a really interesting element to the voluntary self-exclusion study is that we're working to link player card data of individuals who enroll in the voluntary self-exclusion program. So what does play behavior look like during the course of their play at Plainridge Park Casino, all the way up until the point in which they enroll in the voluntary self-exclusion program? And obviously, once they enroll in that program, the player card is turned off or terminated. So it would be really interesting to take a look at that data. The next is the GameSense program. We've received a report on Wave 1, that sort of initial report, and that was back in, I believe, October of last year. So the team was back out with a Wave 2 survey, and this is more dealing with responsible game behaviors and attitudes, how patrons actually respond to the messaging and the GameSense messaging and tools. It will also include a survey of Plainridge Park Casino employees, so that's a different chapter or a different part of the study. And it will also include an analysis of the questions that were asked during the Sigma Patron Intercept survey that I just told you about. So this is kind of a multi-chapter sort of a report that we'll be receiving in late summer of 2017. Finally, but certainly not least, we have the evaluation of Play My Way, and this is the evaluation that we're all anxiously awaiting that will begin to inform our next steps on how we proceed with Play My Way or play management tools. This report will give us a basic epidemiological information of player use, and will provide information about the distribution of gambling metrics of player card gamblers who do and do not use the program. So in other words, what does it look like when you use the program? What does it look like for players who don't use the program? And it will give us some clearer picture on patrons who enroll in the program. This study has had some challenges in getting the accurate, the right data. In fact, I was, right before coming down here, emailing and working with the Division on Addiction, Scientific Games, and Plainridge Park Casino. It has been more challenging than I think any of these parties had anticipated to make sure that we get the correct data sets. I think we're on track at this point. It did end up delaying the report by about a month at this point. I think that once, assuming that we get the right data in the next week or so, that will put the Division on Addiction on a fast track to getting that report done. So when I checked in with them last, they were expecting it to be July. So that's a quick synopsis of the reports and studies that we have coming up, and it certainly doesn't include all of the research activities that are happening. Another highlight that I'm really looking forward to would be that the Sigma team is out of the field now on a targeted survey in Plainville and the surrounding communities. So it's following up after the baseline general population survey to see what are the impacts after a year of operation of Plainridge Park Casino. Do you see an increase in the prevalence of problem gambling? What is the level of knowledge or of treatment seeking of individuals that have a gambling problem, et cetera? It's a replication of the general population survey, but in a targeted area around Plainridge Park Casino.
Mark, on some of the GameSense evaluation and Play My Way, are you taking into consideration the fact that I know you and Elaine have partnered on doing more going through another ad spend? I mean, how does that tie into people's awareness of it? Are you measuring it, I guess, at the right time?
Yeah, I think that we can certainly try to track enrollment based on our new media campaign, and that would be one of the metrics that we could look at. The Play My Way ad of this series is one of the most viewed ads that we have. It's being rolled out through social media. But you're right, what is the impact of that? Can we draw it back to actual admission enrollments into the program? I hadn't thought about that, quite honestly, but we should take a look at that.
That's a great update. I'm just noting here that there is quite a bit of activity coming together in June. There's the CHIA, the Patreon survey, the 12-month operation. Have you thought about how that would be rolled out, presented all at once at different meetings of the commission? I know that some of it converges because it's the end of the fiscal year, and it's also in anticipation of that annual meeting. But what
Right.
what thoughts do you have around that?
Yeah, thank you for that. In an ideal world, we would, and I think we were successful for a period of time where we kind of planned the rollout almost on a monthly basis. We were trying to introduce or roll out a report or study so that there was time to digest it and bring it before the commission. We are, I think that you pointed out, we do have a bit of a bottleneck here, and a number of reports are going to be coming out in May, June, July, so it will be a very busy summer. I think I would like to, the other complicating factor to this, Commissioner, is that it puts a heavy burden on our review, our peer review process. So the RDAS, the Research, Design, and Analysis Subcommittee of the Gaming Research Advisory Committee, an incredibly talented, dedicated group, mostly of volunteers. So we need to, this is going to be a challenge for me, for our team to make sure that we have the appropriate review process in place so we don't compromise that, but that we roll out these projects as scheduled, or at least as closely as we possibly can. I don't want to overrun the commission with reports and studies coming out over the course of the summer. So we may...
You were going to mention the communications strategy, too.
So we'll work with the commission, work with Elaine Driscoll as communication director to make sure that we're releasing these in a thoughtful, strategic way. And to that end, in fact, we are working on a communication plan so that as our reports are nearing the end, almost final, that we employ a communication plan to make sure that the commission obviously knows, but we have a host of other stakeholders whom are affected by the findings, and that we want to make sure that they have the information as quickly as they can, and as we're releasing those reports. So that communication plan is something that we're working on. My hope is that will be done in the next week or so, and we can use it as we bring forward the new employee survey in a couple weeks.
Yeah, let me just mention, you highlighted the RDAS, this group that does quite a bit of great work in terms of the peer review. My sense, and it's just an informed observer, is that they're really good in some areas and maybe not as critical in others, where, for example, timing might be more of a factor. I'm specifically thinking of the operations report. It's important for us to always have the peer review, etc. But they do invaluable work for us when it comes to the other areas, the social impacts, the survey methodology type of thing. And we're, the point is that we're balancing all of those things, trying to release as soon as it's available, because what good is a 12-month report if it's been 18 months? And I'm not suggesting that those are the time frames, but with balancing it with the need of the thoughtful review process, so that we are.
Yeah, great. Those are great points. I think certainly I would like to work with you, other commissioners, and our research teams to make sure that we have the review process. It's not overburdening our research or our review teams, and that the data and reports are released in a timely way.
Well, it's very exciting. There's a lot
Great,
coming.
yeah, it's great stuff. It's really beginning to be, and as we've talked in other contexts, like the Public Health Trust Fund Executive Committee, we're beginning now to have data that can inform our actions. You know, we're getting past the baseline data to the longitudinal data and beginning to learn stuff that we can use to inform our responsible gaming strategies, you know, our mitigation, everything, the conversations with the Public Health Trust Fund, with the legislature, and so forth. It's great.
It is.
You had a couple other quick things?
I just had one other quick thing. Yes, so I just wanted to give you a quick update on the study of gambling behavior among special populations in Massachusetts. So it's part of the 2017 Gaming Research Agenda. The Public Health Trust Fund Executive Committee and the Commission approved a study of, there are 5 special populations that were identified: African American or Black, military veterans, immigrants, Asians, and Hispanics. These groups were identified because either one, the general population baseline survey didn't have an adequate enough sample size in order to give us the type of information we needed in order to really develop prevention or intervention services, and at the same time, these are considered high-risk groups. And then there were a couple of the groups that didn't quite rise to the surface as being identified at risk in our general population survey, but other types of research that we know of would point to these as high-risk groups. We really want to try to, as part of our research agenda, and it's pretty clearly spelled out in Section 71, begin to hone in on vulnerable or at-risk groups to gather more information to inform intervention and prevention strategies. While I can't say a lot because we are technically still in the application phase, we received three applications. Our Gaming Research Advisory Committee, the RDASC of that group, were fantastic in reviewing those proposals. There was feedback that they had or further questions and clarifications. So my goal is that we wrap that up here very, very soon so that we can get those contracts out the door.
Great.
Thank you.
Anything else? Thank you. All right, item 8, commissioner updates. Anybody got anything to talk about?
I had just one. I had an opportunity to listen in on an innovation group webinar about kind of new developments in gaming. I think I shared that with the executive director, and maybe he can forward it along. Webinar was very interesting, talking about the new development of games, and followed it up by doing a little research and seeing some of the demonstrations of some of the games coming out. Virtual reality games that your friends can bet on how you're doing. You know, it's interesting that we're talking about updating our gaming regs, but the technology and appealing to a younger generation is it's moving fast and furious. But Ed, if you would send that link to that webinar around, it'd be great.
Again.
Who sponsored the webinar?
The innovation group.
I participated in a virtual reality game at the last international conference. I was one of the guinea pigs, I guess, and different participants they got to vote on. It was a shooting exercise, so a lot of the class voted for me in this exercise. So it was was really interesting, though. You do feel like you're in the moment with the gear on and you're participating.
Amazing. Anybody else?
Did you kill all the bad guys?
Excuse me?
Did you kill all the bad guys?
Well, I wasn't shooting at people, but I had targets, so I still had a little touch with the target shooting.
Commissioner Zuniga and I have been working with Mark and with the Mass Council on Compulsive Gambling now, and I've mentioned this before, for several months, maybe pushing a year, to see whether we can pull together actually Northeast Atlantic states, because it includes New York, regional voluntary self-exclusion program. And we had one big meeting where we had most of the people from New England, not everybody, but most. And we have another meeting coming up on Monday, which will include New York, where we're going to try to come up with a standardized form. We've got John Glennon and his staff helping us figure out technologically how would we set this up. So nobody's ever done this. There's never been a VSE program that was beyond jurisdictional lines, other than corporations have their own lists. So it's not easy, for reasons you can imagine, but it's coming, and everybody's put their shoulder to the wheel. Everybody would like to do it. It'd be a really big deal if you can. Some of the data from one of the researchers that I saw about voluntary self-exclusion said that 75% of the people who sign up for voluntary self-exclusion go to another jurisdiction to gamble. So the idea of expanding it to geographically related jurisdictions is a really, really powerful concept.
It is, and let me just mention one thing on that. It's something that actually the statute directs us to explore, and you, Mr. Chairman, have taken a real leadership on this aspect. It hasn't been easy just actually finding a meeting time that works for people. We have the obstacles that you alluded to, different requirements, different time frames for exclusions, different history of jurisdictions and approaches, some residing with a tribal operation like the ones in Connecticut, some residing with a commission like us in Rhode Island, etc. But slowly but surely you continue to press the issue, and I think there's hopeful progress in all that.
Yeah, great. Thank you.
One other point, Mr. Chairman. I know we had a lot of stakeholders today from near and far that came to hear us talk about a number of topics, but point out that appreciate the fact that Senator Eric Lesser, who's the chairman of Economic Development and Emerging Technologies Committee, wasn't able to join us, but he did send staff along, and I think that's we haven't had that in quite a while in terms of legislative staff being present and listening in.
Yeah, good point. Samantha Kelly was his legislative aide and was here for most of the day, I think, which was great. I agree. Thank you. That's a good thing to point out. And I just will mention again for anybody watching that our meeting in 2 weeks, typically they happen on Thursday. That would be May 11th. However, we're going to have it on Wednesday, May 10th for our next bi-weekly meeting number 216. Do I have anything else or a motion to adjourn?
So moved?
Second.
All in favor?
Aye.
Opposed? We are adjourned.